The pillows are fluff thanks to Miss Emily. The couch is wide enough, join the family. It's all love while we laugh at Perp's criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Ooh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.
If we can confirm the information.
Hello, Sofa Squad. How are you? Here we are. They're already in here. Let's get going. There's no volume. Wait.
As far as witnesses that you may be investigating,
I don't hear anything. But you know what? I don't worry all that. Do y'all hear something?
If you wish me to hear from the sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
I don't see it, and I don't hear any volume.
Judge,
Hold on, I'm trying to figure out how to
between 12:30
where is the
and when we left the
volume?
jail shortly
I don't know how my computer tends to
from the
reset
sheriff's
itself all the
office
time.
spoke with this officer.
Choose where to play sound. Nope,
Convinced her that it
speaker.
was not in her
There we go.
interest to cooperate with the defense. We are asking for court's assistance because the rules,
To do what exactly?
so that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you, Your Honor. Judge, if I may. Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of the trial. But that part of it, again, these are certain things I cannot assist with. The Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defendants?
No, sir.
An examination for under Sheriff Google by the defense states.
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that
It's on the
information.
record.
After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right, as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, as they have chosen not to speak with you, you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon,
This afternoon is up in the air, and that's going to require some additional conversations with our client.
during the lunch break, that would be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Please bring in the jurors.
And Your Honor, I know that 3 of the witnesses are here. Mr. Descalzo's flight does not arrive until a little after
10 o'clock is
Yes, sir.
Okay, y'all. So Jackie, who is our courtroom correspondent, she got there yesterday afternoon, kind of when they were closing things up. So I gotta read what she said.
neglected to give you an opportunity to speak if you actually want to.
Oh wait, hold on.
So now.
She's telling me where she was in the courtroom. She said, I went to the back row and the judge and attorney were in sidebars. She says, you could see me with the red glasses on the top of my head. A lady with orange hair sitting in front of her. So the orange, I think the orange hair lady's there again today. I'll attach an image. A glimpse of the other dude who said it was Donna and Charlie plus one witness. I was sitting right behind him. As soon as Judge Everett spoke again, he said jurors were going to recess for the day. I made eye contact with one lady who gave me a smiling laugh with a knowing communication of, yeah, you got here late. The bailiff instructed us to remain in the courtroom. The jurors had left the building. That took about 20 minutes, but I was able to overhear conversations about tomorrow. Also, this is the first time I got to experience the end of the day, so it wasn't a lost cause. Apparently, they are calling Charlie and Donna last, and another female who is traveling here. I couldn't catch the conversation, but I believe they said that she has something to do with Wendi. Everett did warn the defense to make sure their witnesses are on time tomorrow. We obviously see this didn't happen. This sounds right because it could take more work getting Charlie in the room and with the Wendi-related woman flying in. There's Jackie right there. Jackie, I'm reading your email. Jackie's with the blue shirt, red glasses.
We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristen Adamson.
Okay, y'all. So then, so Jackie's sitting back there, y'all. She has the red glasses. See the guy with the blue shirt? That's Jackie back there. Looks like she's holding up, or maybe someone behind her did a shirt. Okay. As soon as the final juror walked out, I could see Donna better, and she was all big smiles. I haven't seen her smile at all, except watching the video of her give a little pathetic smile when Wendi entered the room. I imagine tomorrow will be packed. Okay, here we go. We'll get back to it later.
The testimony you will give today will be the truth. You may take your seat. You may examine when you're ready.
Pardon me.
Your Honor.
Okay, I'm muting.
Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Adelson, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again, where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
I did represent Wendi Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that, a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to being close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Did you have that conversation with Wendi Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relook it afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendi Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten court approval for one with a client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes. I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons. But including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the The parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is uh, credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on that financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow. So you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that. And then at the end of our testimony, the judge asked to speak to counsel, which happens a lot. And she took counsel out It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendi's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013.
Yes.
And what was Wendi's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And
subsequent,
before, we had a court hearing trial set, I believe, and so we were able to do it before the court trial.
thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was the, if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion. And then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore. And Professor Markel is not with us anymore. So a lot of people in that mediation are gone. And Ms. Adelson has waived confidentiality.
With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last minute little dust up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined in his opinion what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel he had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back. And I had several friends I knew of Wendy's that were there as well. And it was just sort of a Wendy's in a good place. Come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did. And it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st.
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money. And he owed me money, and I asked for a court hearing on all of that.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Did that prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on and Wendi and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Now, in the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendi's part?
I think he filed at least 1 or 2 more pleadings that did that.
And before we get to the final one, that
Mhm.
you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Miss Adelson.
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, the judge read all of the pleadings and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting. And it was that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to, that they weren't allowed to go to be present at the same birthday parties, that if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't, I think there was a right of first refusal and that she was letting her mom watch the kids, and he didn't like her mom watching the kids. And I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Now, the one motion concerning his, my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they've completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No, it's not possible. And I told Wendi that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that, where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised, but he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, I didn't, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor. Nothing further this time?
Cross-examination.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement. in the-
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that
Well,
time.
I'm always hopeful, but
Right.
And I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes,
Okay, even given your best guidance.
yes.
Okay, that's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay, so that's why they were in the hallway.
That's why
most
they're in the
likely.
hallway. Yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure
courtroom.
you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendi went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they haven't. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then,
could I ask you a different question?
okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien, worst case scenario, he could go to jail. And then him being an attorney though, could he lose his bar license possibly? If he's held in contempt of court, or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt I don't know if, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendi should be disbarred. I mean,
Okay,
that's what he specifically said. That
right.
she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine. And then all of a sudden he decided not to pay the rest. And I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is
And
when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not, we've had a few people get murdered and I've had a few suicides, but it's rare. And I remember all of them.
Right, but not contentious.
Sometimes, I don't know with the suicides, I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor. And first witness.
You may.
Ms. Adelson, I'm going to approach and show you some, I'm sorry. States demonstrative A, I think it's Court Exhibit 1, page 441 of the demonstrative. And then I'm holding 454, if you can hold that.
Sure.
please.
Okay.
Is that the March 26, 2014 pleading that Mr. Markel filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal.
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adelson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling to you.
As far as I know,
You don't know what she said privately, do you?
I do not.
Concerning Wendi Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay.
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down. Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05. Good morning. You can be seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
Okay, so y'all, incoming Paul voice. Incoming Paul voice. We're going to finish reading Jackie's email. Jackie is in the courtroom. She's like off the sofa reporting. She's actually reporting live from the courtroom. We've gone legit, y'all. We've got a correspondent. Okay, now. Okay, so she says, also, I made sure to ride down in the elevator with a large group that were gossiping about how incompetent the defense was, noting that they had 2 paralegals there to look out for things and they still can't get it right, and everyone laughed. It was a packed elevator. Okay, so the dude you'll see in the second image, I forgot his name, but I'll search for it now. Found it, Jimmy McNutty. He was on lunch break video with Surviving the Survivor that I happened to have caught last week, and he apparently goes around and assesses jurors for high-profile cases. You probably know all about him. No, I don't. I'm glad you're filling me in. He's the one I made sure to hop in the elevator with. I held the door for him and the lady he was gossiping with about Charlie and then Donna, then the lady who was flying in. So this is the guy who was talking about Charlie and Donna testifying, I guess. I'll update you again in the morning with what I'm wearing. Sit closer. So she has done this. Thank you, Jackie, if you're listening. I'll bring the right glasses. So yes, we've spotted the glasses are good. I will say that, okay, wait. So if I can sit there, I can see the jury better. I will say that one younger guy in the front row of the jury, white male with brown hair, looked asleep. But when I was walking in, they were in sidebar. The jury indeed all looked tired. There were 2 women on the far end that were gobbling down water, probably to keep alert. One guy in the front row, an older white man with mostly bald head, who I saw this time, and last leaning in, trying to pick up the sidebar. He seems like he will be the foreman because he's always leaning forward and interested. I heard the hour-long video was extremely boring. Yes, it was, but I'll probably watch it next before I finally get some sleep. I want to pick up what I missed at the dentist. She had to go to the dentist. Oh, there's Jackie. And so she had to go to the dentist. So it's, I was like, be careful, right? Make sure it's not Adelson. Yeah. Okay, so let's see some pictures here. Okay, court TV. Okay, yeah. Okay, yeah. Okay, yeah. Okay, yeah. Okay, yeah. Hold on, I don't think Jackie can hear. She has the phone turned off because obviously, like, she's, in the courtroom. Hold on. Thank you. Yeah, so y'all, I zoned out for all that. I'm going to be completely honest. Not all of it, I'm being dramatic, but I was kind of in and out of doing stuff on the other screen and whatnot. I mean, again, like I said earlier in the chat, so if you're just joining, I'll say it again. So last night I recorded like a reaction video to some of Donna and Charlie's phone calls about the bump and talking about Wendi. So like going back and listening to chunks of those again, honey, the case is over at those. She so clearly knows what is going on and is insinuating. She's like, "Oh, the TV costs $5,000. I think it's us." You know, she 100% incriminates herself with the bump phone calls to Charlie. Charlie's already, we're not concerned about little Charlie. Okay, he's just an annoying little flea at this point, right? But Donna, just what this is even more disgusting about it is, you know, she's sitting here on the phone with Charlie and with her grandkids running around talking about, you know, having gotten away with murdering their father. These people are evil, grimy, and they absolutely deserve to be in prison the rest of their lives. Donna deserves to spend her golden years behind bars. So I don't care that the defense wants to get her up there for what reason. I have no idea, right? Why this? What was the point of this we just suffered through? It doesn't matter what all they do. Donna, in my world, is on the phone confessing to the crime. You know, there's why no. The bump did them in. That is amazing police work. Okay, like absolutely genius, amazing police work. There's nothing more satisfying in these cases that we watch where it seems as if somebody might get away with it. Because remember, they thought meaning, you know, the hitman, Donna, all this little crowd here. Oh, honey, they got what they wanted. They thought that they had all, you know, boom, boom, boom. We moved on. Dan's gone. The kids are down here. Wendy's down here. They got their little cars, their little money. Katie got her, you know, her new boobs, all this type of stuff. Right? So they had moved on. And the police were like, what can we do? And, you know, so the bump is, and wait, hold on. Vinny said that they didn't have any evidence against Adelson to the bump. Yeah. So the bump was, the cops basically came in and they were like, because everybody's moved on with the crime, they're not talking about it anymore. So all these like phone calls and stuff like this they were getting, there was no talk of the murder. So they're like, what can we do to kind of bump the train? This is how I look at it, because the train is like Donna to Charlie to Catherine to Garcia to Rivera, who Rivera was already in prison for someone else at this point. So it was like, what can we do to bump the train to kind of get things going? So this is when they had the undercover Sammy approach Donna on the street with a piece of paper folded up, an article about the murder, and with the phone number and 5K on it. And he's basically like, hey, you know what? You had a problem up north. Your family's taking care of so-and-so, but my brother or something like that was involved. He's in prison. He's not being taken care of. Review this. So Donna doesn't call the police. She goes home and calls Charlie, and this starts all these phone calls between her and Charlie and Catherine and Garcia. So the phone number from the undercover cop goes from Donna to the hitman, from the hitman back up to Donna, who Donna will end up calling the undercover cop. Donna, in my opinion, had Charlie not intervened, was going to get $5,000. Because on one of the phone calls to Charlie, when she's like, you need to come over and talk. It's about the two of us, you know. And she's like, you know, maybe bring some money to take me out to dinner. The TV's $5,000. That's how much they asked for. I think Donna was going to pay the money. Now, if she had done that, it probably would have been a wrap right then and there, right? But Charlie got in her head talking about, I'm like 97% sure, okay? You don't know the stuff. Okay, I know the stuff, Mom. Okay, I know how this works. Now, Charlie was just a little coward, okay? He was just a little coward. So he's got on that phone. Donna had to get the phone on the phone herself, okay? And yet Ginger says, what did the men was being stupid and elitist? 100% agree. 100%. And that's the beauty, one of the beauties of the silver lining, let's call it, of this case here, is because when you see what the bump does to them and how it absolutely gets in their heads, and they're so entitled and they're whining over $5,000. These people have more money than God. They're whining over $5,000. Okay. You see how cheap they are. Look at the defense team they hired, right? You see how cheap they are. Okay. This is a Chat GPT defense. That lady in the stand talking about Chat GPT, she's bitter over Chat GPT. She's shaking. She's nervous about her job. She's nervous about her job. She got people walking in off the street with a Chat GPT printout. Okay, she's nervous. When they're talking about Chat GPT is gonna wipe out the workforce, honey, she took that verbatim. Honey, she's been on LinkedIn ever since updating that profile. She said noted. Okay, I got it. Chat GPT, noob. But you see, I mean, literally, Chat GPT is walking around representing the Adelsons in this courtroom. You see, what's her name, Jackie? She's tripping over her pant legs walking up there. Who in there? I get the look she's going for. It's giving businesswoman Jodie Foster, right? Okay, but it's like the clothes don't fit. It's so, she looks so frumpy, right? The clothes don't even fit her. Oh wait, okay. So we got underground report, and Jackie Hearn says Donna has had her snack and is back in the courtroom. Oh wait, hold on. Jackie, can you see what she is eating? Please tell us it's a honey bun. If Donna is eating a honey bun on break, I'm done. Okay, I am done. Back. Okay, so they're coming in. And now I need to go to the bathroom. We'll see who's on the stand next. If Donna's over there nibbling on honey bun, I mean, I don't blame her. I like them too. But I mean, this whole thing is just ridiculous. And the icing on the cake will be if Donna and Charlie both take the stand. Please hold. Literal icing on the cake. They did it again. Witness in the room. No. Jackie, no. Okay, y'all. Jackie's saying that one of their witnesses is in the room, y'all. We cannot with this. I'm telling y'all, Chat GPT, this is the prompt. Generate a defense based on the following information I am uploading. The context is, I have lived a full life, would like to travel some, see grandkids, but don't mind doing a little time. Also, looking to save as much money as possible and cut as many corners as possible. Enter. And it spit out Jackie Fulford and the other one. Judge is going to be like, look, an expert witness. I wonder who the expert was. So, Miss Chris, I don't know if you were watching yesterday, But basically, the defense, so the witnesses can't be in the room that they're going to call. And so one of their witnesses yesterday was sitting in the back of the room for like the person. So they heard the testimony before. And then the judge was not happy about this whole situation. Well, they did it again today. So whoever one of the witnesses coming up has been sitting in the back of the courtroom, listening.
When we advise Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Wendi Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom, whether or not there were any other matters that were discussed along with that. I cannot completely recall at this moment, but we'll review. At a minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to.
Jackie's the one in the back right corner with glasses on her head.
I'd like to know I'm going to the office to check the sidebar. From there, we'll finish this matter. Precedent.
Yeah, judge ain't happy. Donna's like, Javi, can Javi get me another honey bun? Yeah, the Adelsons are all about skimming, right? This is, I mean, you're seeing it play out in real time. Yeah, let me tell you what, Georgia comes in serving every day, y'all. I'm talking hair, outfit, you name it. Lady Casper, you have come at the right time because the defense, number one, the defense absolutely brutalized us this morning with some ridiculous testimony. But then apparently another witness has been sitting in the back of the courtroom. And so it's a whole other thing now. George is over it. The judge is over it. Everyone's over it. What would y'all do if they're like, we're going to go to the board. And they're like, well, we looked up on the board and the defense attorneys don't have their license. Oh, Emily. Y'all, Emily's on her way to Crime Con. Ooh, Emily's on her way to Crime Con. Shh. I heard somebody saying claim your crown because I don't know where this information came from. It was a comment section or an email or a personal conversation. So what I'm getting at is this is not my own original thought here or information, but I don't know who to give credit to. But they had read or saw somewhere that the Adelsons basically hired these people because they knew they were crappy lawyers in order to help with an appeal for obvious reasons. It's like watching the Three Stooges. You know, she comes up there. If I had to liken them to the Three Stooges, if you know who the Three Stooges are, I would say Jackie is the one with the curly hair. No, help me out here. Which one is the curly hair curly, or is that the bald head guy? And Larry is the one with the curly hair. You know what I'm talking about, though. You got the guy with the dark black hair, and then the bald one, and then the curly haired one. Wait, was the last one Wendy's marriage attorney named Bailey? I'm pretty sure they were discussing her. Jake, can I what's going on here? Shoo-ba-doo-ba-doo. Larry is the leader. Okay. So I think that Jackie, not Jackie Hearn, but Jackie Fulford, the defense is Mo. Larry Curly and Mo is the curly haired one. Jake says tutti frutti. Oh Rudy. Tutti frutti. Oh Rudy. About doo 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 da ba da bang boom. Okay. Okay, y'all. I'm gonna since we're doing this, I'm gonna go to the little boy's room. I'll be right back. Please hold. The puppies need me. Shoo-ba-doo. Hello, Emily. How is it going? Are you in the air or are you at the airport? So, y'all, for those that are just joining, the defense has come up with more drama. No. And so we're waiting for them to fix said drama. We have rejected 5 times already today. This is fine. This is normal. I said, shoo-ba-doo. I said, Emily. I said, shoo-ba-doo. I said, Emily is on a plane. Emily's on a plane. Ooh. And she didn't complain. Ooh. Oh, heavens to Betsy. Oh, yeah, we got a little Nirvana for this morning. Got a little Nirvana. I'm on a plane. Jake, no. You go over here. You don't get to eat that. That's not yours. You weren't invited to that. You little vampire. Emily's dedicated, y'all. She's fluffing the pillows from 36,000 feet. We do love you, Emily. I'm excited to live vicariously through you with CrimeCon. Yeah, so y'all, just so you know, so Jackie Hearn in the chat room. Jackie, I don't know if you're, she's in the courtroom right now, so she can't listen to the stream. She can only read typing. But she's in the courtroom right now. She's kind of like doing on the ground reporting to us. And yeah, and so today's going to be kind of a crunchy day because there's already drama. And we were already going to have like a long lunch break. Pardon me, today. And this could end up being a massive break, seeing how this is going, because this is drama that's taking place. Everybody wave to Emily flying over. Emily's flying on a jet plane. Don't know when she'll be back again. That's the only lyrics I remember. Emily's on the midnight plane to Denver. Hey, Shayna. I'm on a plane. Ooh. Oh, thanks, Shannon. Yeah, we don't. Well, we like courtroom drama, but we don't like drama here. That's not fun. We come here to escape. I find the Sofa Squad to be an escape from daily drama. You know what I'm saying? Like a distraction, if you will. Sorry, hold on. So this is an Atkins high protein bar cookie fusion, and it's good. Look at the little decorations on it. Yeah, this is my closest thing to a honey bun. Trust me, I would love, love, love a honey bun. So the poll's coming in. Looks like people are going with we got 2 hours time for food delivery for the verdict. That's what I voted for. I think we're looking at about 2 hours. None of that fancy credentialed stuff. I'm just here for the cringe binge. Y'all, okay, so who all watched, or I didn't watch the whole thing, but Cardi, let's call her Courtroom Cardi. Courtroom Cardi, like highlights from the trial. Even if you're like, oh my goodness, Cardi or whatever, you have to. Oh, Jackie's sitting next to the survivor dude. Tell him we said hello. Tell him the sofa squad says hello. Okay, so Cardi B was sued by a girl who was a security guard at a building. Okay. And basically she says that her and Cardi got into a physical altercation and Cardi hit her or whatever, right? She sued Cardi for $24 million and like, damages, whatever. So Cardi took it to trial. Cardi won. This was girl couldn't even remember. It was bad. If you think this is bad, it was bad. Okay. So I almost felt like the girl's lawyer was trolling her just as hard because it was like all sorts of stuff got brought into it. And like at one point, he's like asking Cardi to describe. I don't even know how they got on this part, but essentially the girl is bigger than Cardi, or at least back then. Cardi was pregnant 135 pounds. And, Cardi's not trying to say that the girl was like, using the F word or whatever. And, it was the way that he was asking. And he was like, what are you trying to say? You trying to say she's bigger? And Cardi's like, she's security big or like security size. And he's like, what do you mean? What do you mean? It's like, and she's finally like, she could guard the building. You have to watch it. I've literally been screaming this morning. And I'm just like, if I was this girl, I would be so mad at my lawyer because it was almost like he was making Cardi troll her, right? It was so funny. Security heavy, yeah. She's security heavy. What does that mean? What does it mean? She could guard the building. I was screaming, y'all.
From the presses from our very capable court reporter. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Please make your argument.
Judge, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened though is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. Witness was addressed at sidebar. You brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point in place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Reviewing Earhart, exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
Which
Absent,
is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that proffer can be taken on this matter. After that, I will step down, briefly review what I need and make a ruling.
Yeah.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple of weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Ms. Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Captain, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No, I don't.
preparations?
Think so.
No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
Okay, y'all. Incoming Paul voice, incoming Paul voice. So, y'all, Jackie Hearn, who's on the screen right now, she's in the courtroom reporting live from the courtroom for us. And what's taking place is a second witness, who you just saw on the stand, was in the courtroom. Now, Jackie's saying she saw the witness outside talking to so-and-so. Y'all, you would think situational awareness, okay, with these people, that if you're in the courtroom, now I understood if you're like a civilian or something like that, but someone like her who's probably done this before and whatnot, I don't know, let me put this up from Jackie. You would think they would know better, is what I'm getting at, okay? So I mean, I get with Georgia, I'd be frustrated too, because it's like they're going to keep doing this. I really just think that this is like the B team, hardcore. There should be no way that Harvey and or what's her name, Donna, is over there like, yeah, we're coming in strong, Harvey. We're coming in strong. We're gonna be walking on the beaches of Nam in no time soon. Okay, you know what I'm saying? Like, there should be no way that she's thinking that. She should 100% be mentally gearing herself up for prison. And maybe she already has, right? I mean, you would have to. Jakey Poo. Now, y'all, what we're going to do at lunchtime is we're going to finish watching, courtesy of True Crime Metrics, the Jeff Lacasse interview with police. This is Wendi Adelson's ex-boyfriend. And here's the thing, too. Emily says, how do they not know to tell a sequestered witness not to come to the courtroom? I mean, absolutely, right? And also on that note, I'm like this. Why wouldn't one of the people over there like be in communication and saying like, hey, don't come in, wait outside, text me when you're here? I think it's part of I think they're literally just trying to get an appeal. They want an appeal. Can't think of a word except for big squeal. Have y'all seen that on TikTok? I don't know his name off the top of my head, but he plays the guitar in Vegas, and all he does is he serenades people when they walk by. But you can imagine the things he's saying. Y'all, it's so funny. Imagine if we had someone like him serenading the courtroom in between. Right? Like, just like serenading it, bursting into song when need be. They won't take a deal. Pigs are gonna squeal. Jake's looking at me like. Jackie says the group around me are all talking about appeals. Yeah, definitely. Oh, excuse me, I'm sorry. Definitely agree. Jessica says going for ineffective assistance of counsel. Absolutely. I like Judge Everett too. Yeah, if we had a serenader in the courtroom right now, this would be entertainment, even for the people there, I'm sure. Emily, I hope your flight's going well. I hope your traveling's going well. Oh, goodness. Oh, goodness. Hey, na, 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 na. Yeah, Amy will play us a new tune on her new piano, right? There should be a baby grand piano in there somewhere. Jakey Boo. Now some other things coming up. So Aaron Patterson, they are going to air her sentencing. That's going to be Monday. Obviously, we'll see what's going on with this. It might be a rewatch that we have to do. If there is a way that we can catch it and stream it here, 100%, right? And then at minimum, we'll be covering it clearly. What was the other thing I was going to tell you? Barry Morphew. In fact, you know what? Let's get some updates here. Please help. Your call is important to the sub squad. Okay. So let's go with this. Colorado judge denies reduction of Barry Morphew's bail, modifies bond terms for alleged murder of wife Suzanne. Barry Morphew appeared in a Southern Colorado courtroom for a hearing on Tuesday, and the judge opted against reducing his bail but did modify the terms of his bond. Earlier this summer, Morphew was arrested a second time on suspicion of murdering his wife, Suzanne Morphew. She was reported missing on Mother's Day 2020 from Shelby County. More than 3 years before her remains were rediscovered, approximately 45 miles away. Okay, hold on. Ooh. Barry Morphew appeared in the Alamosa County courtroom on Tuesday afternoon wearing street clothes, including a flannel shirt and blue jeans instead of his jail uniform. Even though he remained in custody of Alamosa Sheriff's Office, he was arrested on June 20th in Arizona and extradited to Colorado. The hearing centered around a motion from the defense to reduce the bond for Barry Morphew. His bail was set at $3 million. The defense requested in court that it be reduced to $500,000. His defense attorney maintained that Barry's past conduct should be considered for a bond reduction, as well as family connections in Colorado, including his daughters and his mother. Prosecutors argued against changes to the bail amount, stating that Barry Morphew had been operating his business under a different name and that he didn't have any direct ties to San Luis Valley community in Alamosa County. The judge said that she wouldn't reduce the bail amount but did modify the terms of the bond. The bond was changed to a cash surety or property bond. That means that a bail bond company posts the bail on the defendant's behalf for a non-refundable fee, typically 10 to 15% of the total bail amount, which means that he could pay $300,000 for the bond. The judge also added additional conditions to the bond terms for Barry. He must surrender his passport. He may not leave Colorado for any reason. He has to wear GPS. He can't leave his home for any reason except to appear in court, meet with his attorneys, and attend a doctor's appointment or for a medical emergency. He must only use his real name of Barry Morphew. He must only drive vehicles registered to him. He may not possess or control any firearm. Okay, let's get here. So that was it. It's not clear if he's posted bond or if he'll be able to. We'll see. So right now, for people who are just joining, we've been in a major conundrum. The witness has been in the audience, heard other witnesses, apparently talked to other witnesses. Oh gosh, hold on. Apologize, sorry, cut the aunt. And so now they're trying to decide if they're going to allow the witness to say. So, oh goodness gracious. So that's what they're doing. I say, hey na na na, hey na na na. Y'all know that song? Maybe I should start DJing here. In between, we can do a little DJ set. We'll make up our own songs if we run out of them. I said a shooba dooba dooba, shooba dooba doo, dooba dooba dooba, dooba 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 dooby doo, dooby, shooby dooby, shamon, dun 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 dun. So yeah, so we are sitting here just waiting. Okay. I think today's going to be a messy day. I think it's going to be a sloppy day. There are alleged rumors of both Donna and Charlie taking the stand. We shall see. I think what they're going to do, and this would be how I think any case goes, right? When they're done with their testimony, it's like, that's it. I think that they're going to go to Donna and say, do you want to testify? You know, what's up? What's up? And I'm sorry. And I think that, I mean, I personally wouldn't, but knowing Donna, she's going to be like, y'all have done a terrible job. You're not getting one penny, and you're certainly not getting a grand piano. Okay. I'm taking the stand. Okay. Hold my beer. Okay. I'm going to show you how this is done. And she might talk her way out of it. I mean, I'm not going to, but she's been pretty swift so far. Right, Allison said it's already a messy day. It really is, isn't it? It's just a messy day. Messy, messy, messy. We need some Cardi B. Um, you know what we're gonna do? Please hold. Please hold. Your call is important to the Sofa Squad. Okay, y'all. All right, they're back. Okay, I got a Cardi B. We can do a Cardi B best moments like over the break or something. I'm over here cackling. I'm over here cackling. She is some good. She is some good. What do you call it? Levity, like to add humor, you know, lighten things up or whatever. Oh goodness gracious! Tori and Tux, I hope y'all are doing well. I said my name is Car. Okay, here we go.
Concerning this issue of the testimony of Wendi Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. concerning how the jury is to be instructed at the end of the trial as to this testimony specifically. If the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.
Now would be Jackie Hearn's time to stand up and say,
Additional matters that need to be clarified.
she was talking to someone outside.
Any more issues with witnesses or other problems?
You know Georgia's going to bring it for the closing arguments. She's going to have snark upon snark. If Donna or Charlie takes the stand, y'all, the snark from Georgia is going to be amazing.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give?
No situational awareness whatsoever.
Examine as you're ready.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
We've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
And do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course, you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines. But at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to order the witness as to their training or experience. In objection to her ability to provide an opinion in the fields of marital family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email. And I reviewed the emails that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going. And it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel. Which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary. But then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage. So you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out on themselves, by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now we're using the term time sharing. We also have during the trial heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
And so the term custody is not something that is used in family law proceedings any longer.
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 4951.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation. And then he had filed a motion to enforce life as he would have liked to have seen it. And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce.
So,
and then,
in other words, he was asking the court to enforce something that they had agreed on, but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So he would, let me understand correctly, he was asking for court authorization to be able to to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendi that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And Based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by, telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markel case, other than that June 21st, 2013 hearing, Were there any other, did they litigate any other issues?
During the divorce,
Yes,
up through July 31st?
yes.
No, no, they resolved everything, temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
no, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally, if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company,
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. That makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No, we have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come
Then-
back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied. Did my client in the emails you review appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace. I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adamson?
I saw no evidence that Wendi shared them.
Okay. And did you speak with Miss Adamson about that?
Yes.
Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more think it was more like 45, 55, something like that. It was, instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, childcare, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah, yes.
Now, later,
It was very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days. So that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation would be dismissed. So
now, prior to final judgment being entered, would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Nothing unusual about
Routine.
that. Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think what the state provided to you, which was between maybe April of 2014 through June of 2014. So it's a few month period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. You know, I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so that she could execute on the judgment and collect her money.
So although the motion itself may have been entitled contempt, enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, you know, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? Approach with courts 1 states demonstrative A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution, and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kid said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to the Schwab account that you've heard about, a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that. And it wasn't legally supportable. in my
That's not a
opinion.
valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adelson referred to. It's called 12.540. And that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle.
Sure,
to
and it had to
overcome.
have impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendi on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go have dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them. And they were little babies. And he didn't like that because he wanted to be able to go to the childcare during her parenting time so he could see them every day. And I think the childcare person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed a motion to dismiss on March 10th. to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest. And there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not. But I would like Wendi to make it stop if it's true.
Did the grant this motion, the March 26, 2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.4 or 5, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids, even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert eye roll here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have. And that's one of the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendi of that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because like Ms. Adelson said, relocation is extremely difficult, and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel been able to sustain his burden of proof for that motion?
I'm sorry, say that again.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. How many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
May I show the witness the demonstrative?
You may.
Volume 1, Volume 2, Volume 3, Volume 4, Volume 5.
There are questions for the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
And these 10 volumes a example of a hotly contested relocation case?
Well, and I just count 500 pages per binder. So that looks to be about 5,000 pages. I think the actual pages were over 10,000. So this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal. So perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, please.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the.
Members of the jury, the bailiff will take you to the jury room.
Incoming Paul voice. Incoming Paul voice. Did y'all hear the judge when he said, "Can we approach?" He said, "Mm-mm. Mm-mm. Not really." Judge is annoyed too. The judge said, "No, this is ridiculous." Y'all, I've been zoned out. Ain't no way. They had to have just woken Jackie up. Not our Jackie. Jackie Fulford.
You may be seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same as to issues of relevance. Again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Then why did you dramatically set it in front of her and leave it up on the thing? Like they ate, like here's our mic drop moment.
Ms. Bailey, please step down, step out of the courtroom doors. If you can radio Deputy Bump to leave the jurors in the room, please approach.
Now Jackie's upset. She's gonna have to shuffle up there. Look at, no, she is not wearing that. You know, George is silently judging her. I mean, we are, but we're saying it out loud. Y'all, surely they're gonna send everybody to lunch. This is ridiculous. And we're doing like an hour and a half lunch today, I think he said. Oh my goodness. Yep, my goodness is right, Sean. I've been zoned out. I've been in the portal. I've been in distortion.
To remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Jurors using the restroom. Please use the restroom or stretch your legs if you need to, and continue with the witness after that.
Y'all, what happened to lunch? I'm really concerned about the lunch. Yeah, I gotta take this. I gotta stretch my legs and do all the things the judge just instructed us to. Y'all, let's take a moment. Let's do a refresher and do a little bit of Cardi B's highlights for a second. I can't with this.
I was looking at her face, but I wasn't looking like she got a pimple on her face. No, I wasn't looking at her details or anything.
Oh, Cardi B on trial in a civil courtroom in California. Welcome back to Opening Statements. So we know that Cardi B is being sued for $24 million by a security guard who is claiming that the rapper scratched and injured her face. Now, Cardi B disputes it, and she did not disappoint on the stand. Take a look at some of her most memorable moments.
I feel like when I got sued, I was like, when I got sued, I was like, oh, I know I didn't touch her. Like, it's like, look for the cameras because they'll tell you. I personally feel like if there's no physical touch, there is no incident. There was a verbal altercation. If you think that that's an incident, a verbal altercation, then it's an incident for you. So, oh, yeah. She also was saying, like, this, I don't give a who you are. I don't give a who you are.
And why were you concerned?
Because I'm pregnant and this girl's about to beat my ass. Hello? She told me, when I told her, why are you recording me? She said, oh, my bad. Practically apologized.
Did she apologize to you?
If you say, oh, my bad, when I'm telling you why you're recording me, to me, that means you're recording me. And it's right there right now. It's on my face.
Court is dark today. The jury gets an extra long holiday break. No doubt, though, the attorneys are hard at work preparing to give the all-important.
Dr. Fink did a great job. I think this is a complete win for the defense. I'm still shocked that it went this far. But anyway, that's what I would do. Focus on Cardi B.
Right.
Whether you assaulted and battered Miss Amani Ellis, correct?
Just no, I guess so, but I didn't touch her.
Okay. In addition to owning defense counsel when she was on the, or plaintiff's counsel, I should say, it was plaintiff's counsel or opposing side's counsel. She also served up some really gorgeous courtroom looks. Every day, optics matter with her.
Julie, if this were a different type of case, you know me, I'm totally into pastels, right? This is not that case.
I thought that was going to be a better one. Let's just see here. Okay, I'll find some more clips later. But yeah, she was. I thought there was going to be better ones, but there. I mean, it's literally y'all. It's pure comedy gold. Um, okay, so I'm gonna run to the bathroom real quick, and then we'll keep going. Wait, what did Jackie say? Hold on. Oh, Jackie says we may not get a lunch. Oh no, they're probably running behind. I mean, this is ridiculous. The defense isn't gonna win any friends if they take people's food away from them. Take the snacks. Oh please, absolutely not. I'll be right back.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but.
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
It shouldn't have been. There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that we would strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendi. Jail is not a possibility on that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendi. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
if there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adelson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witness has provided an opinion. The state
Well,
will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendi have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead.
George is like, should I go ahead and mop her up off the floor with this last thing? George is like, hold on, I'm going to take some notes now. I'm about to clean her out. She's like, you want me to say something about the grill? Are we going that low? Okay, I better not. You're right. Y'all, there's no way the jury likes this witness. There's no way. She's so obviously just paid for her trash. Ain't no way. Jackie, not our Jackie. We have to come up. What are the odds that we have Jackie Hearn, Sofa Squad, in the courtroom reporting, and the prosecutor, the defense's name is Jackie too? Defense Jackie is sitting over there, the same confused look on her face. Yeah, Tom Petty, thank you, Diva. Yeah, George is getting ready to come in with the Cardi B. She's getting ready to Cardi B her butt. Send her on her way. She just even looks like here's the thing. This lady right here on the stand, she's just taking money. She's just taking money from people to do this.
Redirect examination.
Please don't. Oh, please make it brief. Sofa Jackie, I like that, Miss Ohio.
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
Well, look at there, 2:20. We got a nice little break. Yeah, Deshaun says the defense is free falling. And they're free. Free falling. Yeah, that was some of the most painful.
Everyone should be seated.
Here we go.
Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioned the gallery again. I don't know what steps the court, needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is this coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Mr. Splazo, I believe this is called by the defense.
Mr. Splazo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of the witnesses are present, so we do not have any continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
No, I can't. Yeah, now here's what we're gonna do. So I want to go make my lunch, do all that. If Jackie's in the chat room, wait, Jackie's right there. Jackie says the only people talking about the front row. Hold on, Jackie, can you get T on if Charlie is testifying today or at all? So what I'm getting at, y'all, is if I've walked away and she answers, will y'all remind me what the answer is when we get back? And Jackie says that was complete BS. I bet it was Georgia. She was over there sighing. That last one was. Here's the thing: people see through this, right? The only people that have gone up on the stand for the Adelsons are lying and conniving people. Even the sweet little old lady friend of hers, and I'm especially this woman who was just up there. It's just, I mean, just horrible people. Yeah, Lou says he barely scanned the courtroom for. That's sad when the judge has to be like, scan the courtroom, see if your witnesses are in here. Yeah, paid consultant diva says, yep, that's it. That's all. Okay, I'm gonna go over here and pull up our you know what I'm talking about. You know what I mean. Jelly bean. I said, hey now, hey now. Again, y'all. I said, hey. I said, hey. Oh. Okay. So y'all, court resumes about 2:15. I'm just gonna be over here. I'm actually have to take some new thumbnail photos of going. Send to the people. So I'm gonna be doing those and eating my lunch. I'm gonna be feeling stupid, y'all. I'm gonna be feeling stupid. Hey, Aaron, you see me rolling. Dun, 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 dun. How's it going? Aaron, if you've been watching the trial, what's your lawyerly tea on everything? We've got in the courtroom reporting going on here from a person in the gallery. Okay, I'm gonna go. So we'll be back at 2:15. I'll probably be back in the chat room in a minute. I'm just gonna go back and forth. Thank you, everybody. Thank you, mods, for being here. I appreciate y'all. Silver Squad, I appreciate y'all too. Y'all make it possible. I love y'all. Bandit, you've missed apps. The only good thing that's happened today is Georgia just ate up that last witness. That was it. Other than that, it's been torture. Literal torture. I said, hey now, don't dream it's over. Hey now, hey, thank you, Carol. Yeah, we got an update from Emily. Fly safe. Fly safe. Don't tire your arms out. Didn't shh. I love a good dad joke. Oh, I love when the judge said no. The judge did say no when the defense was like, "Can we come up? Can we approach?" And the judge said, "No, not really. Clear the room. I'm getting ready to eat this fool up." What's funny is you can collectively tell that everybody's over the defense. I mean, it's literally insanity. Hey, we're all good with unpopular takes. We're all good because I'm always interested to hear what the and I'm responding to Aaron Simi Rowland. Aaron Simi Rowland's a lawyer. I'm always interested to hear the more technical, if you will, because obviously this is coming from like uncredentialed, like whatever. I'm not looking at it through the lens of like how another lawyer might view the points and things of this nature. So no, it's always welcome. I enjoy that. The judge is so adorable. Okay, Aaron says unpopular take. If Donna testifies, I don't think Georgia should cross. Okay, and what are your talking points for this? I'm invested. I'm invested. Do we think that Donna could live through a? I mean, Donna or what's her name? Georgia's cross-examined Charlie. I mean, she eats. I mean, y'all have seen that if you follow this. If you haven't, it's pure beauty. I mean, she eats him up. Georgia just has a good exaggerated way of, what I'm saying? Yeah, I gotta go make my lunch. I'm gonna be here, but I'm gonna go back and forth. Came back from lunch to respond to Aaron. Aaron, good points there. So per and I looking at it from that of like, because there is the optics. I can see that. Now, for me, like the petty side of me, do I want to see Georgia eat her up? Well, obviously, right? But yeah, if she gets a little too rough, Donna's going to definitely play that vibe up. And again, the evidence speaks for itself at this point, in my opinion. I mean, especially now that we see what the defense given their saying, which is nothing. I mean, if anything, they've insulted the victim, his family, the whole 9 yards. We're close. If I was Donna, I would heavily consider a feigned medical situation in the room, right? That's the point I would be at with this. Possibly to try and escape from the hospital, if at bare minimum. Oh, okay. I'm gonna go make my lunch, everybody.
Person. She's a friggin' humanitarian on the web, right? I mean, human trafficking and social work.
Do what now?
She's like a humanitarian if you look her up on the web.
Okay.
She wants to be seen as this ethical, loyal person.
Okay.
And she couldn't handle it. So she like lost her shit in a way I just want to say I've never seen. She sobbed, but the next morning she sobbed all the way from Gainesville to Tallahassee, and I was upset, but it was.
But I thought, and you're just gonna have to bear with me
Sure,
as
sure.
far as I thought that after I can see that she's in this fetal position,
Yeah.
she's demoralized,
Yeah.
whatever. And then I thought she snaps right out of it and says, I had a great time.
That's what concerns me. Is I used to work in a psych hospital. I've seen this kind of stuff before. It's a good question. she was vacillating between, it was crazy. 1 minute confessing, literally telling me I wanted to sexually experiment with people. I wasn't ready, you know, this kind of stuff. The next minute, I never did that. I mean, it was like insane.
Contradicting what you just said?
Absolutely. And on the way back up, she goes, I never did any of that. I said, well, you confessed to me like 7 different times last night. I did not. It was crazy.
Okay.
Absolutely insane. So if it doesn't make sense, I understand because it didn't make sense.
Okay. Let me go back to this special forces guy.
Yeah.
Okay. So are you Charlie's friend on Facebook?
I was.
Okay, you were.
I was. It wasn't until all this stuff happened and then I defriended everybody that was associated with Wendi just to clean my life up.
Okay, but when you were on the Facebook, a friend on Charlie's Facebook page, you're saying that this guy that you knew as being a special forces, ex-military, psychopath, whatever.
Yeah, by reputation.
Okay, by reputation. Did you ever hear a name being called?
There's pictures of him and Charlie together on the page. Though.
Okay. Do you have any of that saved?
I don't.
Okay.
I don't.
Can you describe the guy?
I couldn't. I mean, he's a big guy. He looked like a
tattoos.
Tattoos, looked like an ex-ranger or something. And Charlie doesn't have that many friends. It can't be that hard to track down because there's like this foursome of them that hangs out, and my memory is that he is part of Charlie's crew, you know.
The inner circle?
Yeah.
Okay.
Yeah. And certainly Wendi talked about him a lot. She'd heard a lot of stories, you know. So
She can't recall a name?
I can't.
Nickname?
There's all these crazy, and I can't remember the stories, but all these crazy stories when these guys were drinking and partying and stuff, but all stories like that, you know, drinking stories and things like that.
Okay, was there any other, so this was just what you're seeing on Charlie's page.
Mm-hmm.
You didn't have interaction with this guy directly?
Never met him. Wendi talked about him periodically because she found him amusing. She'd met him a few times.
And what was?
He's crazy. I mean, you know, but in a fun way. It wasn't like negative. And I mean, if Charlie arranged a killing of Dan Markel, I don't know that it would be that guy. He was just the first guy that popped into my head. Like, well, that's got to be something I was looked at. I mean, you know.
So you're basically putting this guy's face as someone who would carry out the wishes of Charlie.
Yeah, because these guys are close friends, is my impression through Wendi. Also, this sure looked like somebody who had done this before. This guy's reputation is that he was doing building to building combat in Fallujah or whatever, so it wouldn't be a new thing. So that's why it popped into my head.
Okay, was there any, you know, and we're just talking,
Yeah.
but was there anything that would lead you to believe that this person had committed something like this before?
No, not at all.
So it wasn't like, you know, here's G.I. Joe and got 40 kills under his belt or anything like that?
Oh, I think his reputation was of a combat hardened veteran that had seen real stuff.
How is it periodontist or whatever, Charlie, is some type of specialized?
As a periodontist, that's right.
Okay.
He's a very interesting guy, and you may have known guys like this. I know some in Tallahassee. He's friends with people on both sides of the tracks. He's got friends that are physicians and professors and all that. He's got guys he hangs out at his gym that don't have a high school diploma. He's able to buddy up with them too. He's very good socially. Charlie is street smart. He comes off kind of like a con man. He is really good with women. He's one of those con man womanizer types. Different girl every night. Very social and smooth. So he enjoys flowing from one side of society. He has a Ferrari. I mean, he could just hang out in the upper crust. He doesn't. He enjoys slumming with these other guys, you know. So I think he's taken trips with that guy, though. If you're going to look into it, I believe he's part of the crew that like went to South America.
I have somebody checking right now to see if maybe we're talking about the same person.
Yeah, I don't know. I mean, by the way, Charlie is so industrious and so street smart that if it wasn't that guy, it wouldn't make me any less suspicious that Charlie was involved. He just was the natural first thing that popped into.
So what do you think, Jeff? You don't. Okay, so when you first started talking to me today, and don't take this the wrong way, but when you first started talking to me, I thought we were fixing to crucify Wendi right here as far as everything, and that she was directly involved. Not necessarily that she kill her husband, ex-husband, but had solicited for someone to do it.
I still believe that. I'm 100%, I never say 100%, I'm a researcher. I was 90% sure when I talked to you guys in July, when I was waiting for you to catch somebody, because then maybe I'm crazy, right? So then when Myron May happened, I thought maybe it was Myron May, I'm just wondering. At this point, I'm pretty confident. I got a couple, can I give you a couple other things?
Yeah, but just slow for me, please.
Yeah, because there's a couple others, just two other suspicions.
Let me just, before you get into that, I don't want to throw off your train of thought, but I want to address this. This is an email that I think you're referring to. I'll give you an opportunity to read it.
Yep, that's the one she sent, that's where I'm going right now.
Okay, so this is July 15th, is that accurate?
That's right.
Okay, July 15th is the Tuesday before.
The thing she told me about Charlie would have been the night before this.
Okay, so we are on the 14th.
Yeah, I think that's right. Yeah, it would have been Monday, July 14th. That's actually just where I was going for right now.
Go ahead.
So she goes to South Florida for 2 weeks. We barely talk. It's hard on both of us. You guys have emails. It's bullshit romance stuff going back and forth. We had one long conversation and decided to patch things up. She sounded very calm in this conversation.
These are phone conversations?
Yeah.
She's in Miami.
She's in Miami. And while she's in Miami, she says, she would just disappear for 14 days. I wondered if there was another man down in Miami too. It seemed plausible because her parents take care of the kids. It doesn't make sense how busy she is. Come back Monday, we go on a date. That's the 14th. That's the night that.
Okay, you're on the date here.
Yeah, we're on a date here. It was real awkward. And she was a little strange, but it was overall a pretty positive date. So I had some hope in terms of the relationship. She said that thing about Charlie. I was so distracted by this relationship stuff. That's the reason I didn't follow up on that bizarre thing she says about Charlie having Daniel killed. But at the end of the night, she wants me to drop all the Daniel Sack stuff, everything else. She goes, that never happened. And I said to her, Wendi, we can break up, but I'm not going to go on a relationship pretend like this didn't happen. It happened. So she's not Danny's the only relationship she ever had. I said, I know you don't know how this works, but if you want to go to a counselor, you can, or you talk it out. But you don't just say that never happened. This happened. And she seemed to find that devastating. Back to the who knows about this, who's going to know about this. Does your friend Steven know about this? Oh, Jesus,
That's on the 14th.
It's on the 14th. So
that you're having this conversation during or after your date?
After the date.
Back at her house?
Back at her house. Back at her house. And didn't have wine that night. She was sick. She got back home. She was really stressed out and sick. So the next day is Tuesday the 15th. Wake up in the morning. I call Wendi and I told investigator Hill this. I don't know if there's anything here, but it was kind of bizarre. Talk early in the morning, maybe 9 or 10. And I said, I'd like to see you today. I was a little encouraged. And she said, yeah, I'd love to see you. And she'd locked herself out of her house. I said, well, come hang out. She said, I'd love to spend time with you. And then I waited. 3 hours later, I get a phone call, and she's like, actually, I got into the house. Let's not do the afternoon. Let's just go to yoga together. So
where?
Yoga.
Okay.
So I went to yoga together. It was awkward as hell. She was cold. She was done. I could tell. So I'm sitting there yoga going, okay, this is over. Walk her to her car at the end of yoga, and I say, I love you. I don't know what else to say. And she goes, I know. I was like, well, that's not ideal.
So I love you. And she goes, I know.
Oh, yeah.
Of course you do. I'm a goddess.
I'm about narcissism.
Yeah.
So I literally went, okay. I just turned to leave. And I'll hail this, but I want to say it again. She goes, hey, Jeff, are you still going to Tennessee on Friday? And I say, I'm thinking, why the hell does she care? It's obvious.
You're walking away, you're separating?
Yeah, I went 10 paces away from her, and she says, hey, Jeff, are you still going to Tennessee on Friday? And I say, I lie. And I say, actually, it's up in the air. Because we talked about if we broke up, I should come over and say goodbye to the kids. I was hoping she'd invite me over. And she said, well, she was deeply interested. She asked me 3 or 4 questions.
But this is after this, right?
It is after. No, that's not. I get this email at the end of the night. She goes home and she sends this email. This is after this. This is after the conversation. The conversation I'm telling you about right now happens an hour before I get this email.
An hour before. Okay, so we're still Tuesday the 15th?
Yeah, at 7:00 at night.
Okay. Okay.
So she asked 3 or 4 questions about under what circumstances would I go? Why am I thinking about not going? She seemed deeply interested in what I'm going to do on Friday. It just was bizarre. I was like, well, whatever. Got home, got this email. What was so strange about this? We had just spent 14 days, 16 days away from each other, thinking about things. Then I get this. I told her, if you don't want to do this, send me a text and say I can't do this anymore. Why would you string me along for a week? It's real strange.
I just want to make sure that we're on the
Yeah,
same page.
yeah.
And I'm going to read this aloud. So, if there's something, it pains me to be writing this to you now, but here we go. I need some space to clear my head and to figure out how to move forward. I am heartsick, but my head and my heart are having two different reactions to us being together, and I can't reconcile them to be in this like you would want me to be. So she's saying you're coming on too strong, basically, is what I'm reading. You want a full commitment.
No, that's not how I read it, but I mean,
Well, I mean, that's how I'm looking at it. Is that not true? I mean, okay, do you want a full commitment from her?
I wanted to continue the relationship, yes.
Okay.
But we had discussed just breaking up. We just spent 16 days apart thinking about things.
Right. You're 16 days apart. Then you go on a date on the 14th. She makes the comment about her brother was looked into killing Danny the previous summer, which had been summer of 2013. She didn't specify a month. You didn't question her any more about that.
I was too focused on this stuff. Yeah, I didn't.
No, you make that when she's making this statement on the you're saying the Monday, which would be the 14th.
Yeah.
When she makes this statement that Charlie had looked into having someone do this for 15, it was going to cost. Hey, how much does it cost to kill this guy? And the answer that Charlie gets is $15,000. He shares that with his sister.
Yes.
Okay. And then she says that to you. And that was in the context preceding that conversation was basically, what do you want to do? You don't like it here. I'm talking in your.
That was part of the conversation. There was constant conversation about Danny is awful at Tallahassee sucks. That's not all she ever said.
And I can't do anything. I'm stuck here because, I guess she got denied relocating with the kids. And she's saying, I'm stuck here unless something happens to Danny, what you're getting at.
Yeah, that's exactly what I'm getting at.
And then she just spills this out.
And then I think, by the way, she just went to the bathroom. I think there was something like that where
But you're saying that, I mean, there was no more conversation about, this is huge to me. This is like, my brother's already checked into it and it costs this much. Is it like, this is still available and open, or 15 grand is too much we're too cheap?
This family's rich. I mean, that's nothing.
No, I know, but
what's that petty cash in his office?
Okay, but was this like, this option still available? Is that how it was?
It was just said in passing, and I've mulled it over in my head 100 times. I didn't know what it meant.
Okay, so my brother checked into it and it was going to cost 15 grand.
I'm just heartbroken in this situation. I'm not thinking about that. I'm thinking about how do I get this woman back.
I realize, but I'm trying to glean this from what the interpretation that you got from it.
Yeah.
I know you told me you didn't ask for anything more about it. I mean, a statement like this, don't take this the wrong way, but if I was in your shoes, I'd be saying, what the hell are you talking about?
I got used to her craziness. That's okay, right? So she's all over the place all the time. So I think I just wrote it off as another crazy thing Wendi says.
But you recall the amount.
I do, and I went back to a couple friends because I told them about this after Danny got shot. I said, holy shit, I mean, that's what happened. So I beat myself up about that.
No, I don't want you to beat yourself up. I just want to make sure that you didn't. I'm just trying to get you to see, is there anything else that you can recall? I'm not saying you did anything wrong.
I know, I get that.
I'm saying, are you sure you didn't miss something else in that conversation?
No, because it was right back to her and I.
Okay. All right.
Since you're going to be here, and that's not going to happen,
So this comment is made in passing as she's traipsing off to the bathroom.
Like, her bedroom or something.
Comes back out, it's all.
And I say, I had a good time last night, or something like that.
Okay.
It was that kind of thing. So she sent me this email, and I don't know if it's coming on. I didn't know what to make of it. I sent it to some of my friends who know her pretty well. It said, she's crazy, is what they said. I mean, why wouldn't she just break up with you? It doesn't even make sense. I should have broke up with her. But we've been apart 16 days. She wants another week. But recall that when she left Danny, she just moved out while he was gone. So confrontation isn't her thing, so maybe that's why. So Wednesday goes by. There's Thursday. Thursday, she.
You're still up in the air about leaving. You've told her, I don't know for sure if I'm leaving Friday or not.
That's right. She doesn't know for sure. I don't know if she would have or would have known. We have mutual friends that I told on Wednesday or Thursday that I was going, that it wouldn't shock me if she were able to find out that I was going. I mean, we have mutual friends.
But your answer to her was, I don't know yet. It's still up in the
That's
air.
right, that's right. But the next day I decided to go. So it was
On Wednesday.
Yeah, I decided to go for sure on Wednesday. Thursday, she changes her Facebook picture. I'm sure you've seen the picture of her in the beautiful purple dress. It's all over the media. And that was bizarre to me because that's a Victoria's Secret dress. It's not a dress you hang out at your parent. You might wear it to a club if you're an undergrad. You might wear it to bed. You don't hang out at your parents' house wearing that dress. And to me, it was.
Was this a dress that you gave her?
No. But you saw the picture. It's fairly scandalous.
Okay, I see what you're saying.
But if you went to Google and type in Wendy's name, she's a pretty girl, but you'll find nothing where she looks even close to how she looks in that picture. She looks gorgeous in that picture.
On the Facebook?
Yeah. Okay. And it was suspicious to me after the fact that picture was changed 12 hours before Danny shot, and that's the picture that was distributed to the media. She's very concerned with her appearance and how she looks. So I know that maybe sounds crazy. Investigator Hale seemed to think it was, but I thought this is so strange. She changed her Facebook picture twice in 2 years. And the night before Danny's shot, and she's going to be all over the media, she looks like a Victoria's Secret model, you know?
Okay.
So, but I was bothered enough by that picture because
What was the prior picture?
Something that looks more like a 35-year-old woman with 2 kids would have on her Facebook page.
Okay.
All the other pictures, and she looks pretty enough, but that one looks, she looks amazing in that picture.
Okay.
She's not even that pretty in real life. That picture, I think her dad photoshops that stuff. He does that kind of thing. So it was a picture produced for her by her father, I believe. So Friday I leave. Thursday night I leave. About an hour after I saw that picture, I said, fuck this. And I just drove out of town. The next day, Danny shot at 11 a.m. No one contacts me, which we have a lot of mutual friends, and they didn't. I talked to some of them after the fact. They tell me that they were under the impression that I was very likely an actual suspect in this case. I posted on Facebook from Tennessee Friday night at a time where it would have been impossible for me to ever have been here at the time of the shooting. I found this really puzzling, and what some people have told me after the fact is that you guys searched Wendy's stuff. It says talk to Jeff about stalking in her calendar. If somebody was stalking with you, would you need to write yourself a note to remind yourself to talk to somebody about it? Mm-hmm. It's real strange, especially since I never did anything approximate. I snooped. I conceded that I snooped. If I could have any options, I don't feel badly about it at this point. She didn't contact me for 10 days. She told me that the police had instructed her that I was a suspect and she was not to return a text message that I sent her. That she could not do that. I actually recently dated a criminal defense attorney, just coincidentally, and she thought that was bizarre because she said they want you talking, you want to incriminate yourself, they're going to get access to this stuff. But
that didn't come from me.
I don't think it came from anyone. It was very strange. Well, I know legally you can't do that probably, but
no.
I mean, why would you want to? So I wasn't in the room with her. I don't know how she acted or whatever, but it was implausible that I did this. And I don't know. She told me I tried to protect you from the police. They want to know where your house was. They want to know this. I said, I don't need protecting. How come none of your friends called me or texted me? Well, they told me later that she seemed to be concerned that I actually did this.
Why would you do it?
I know. Why would I do it?
Well, what did she say? Well,
crime of passion. We're breaking up and Jeff's upset. Why would I go kill Danny because I'm upset with Wendy? And by the way, as soon as I heard he's dead, I said, that's it for us. She's back in Miami. That's it. I knew. It's the dumbest thing ever. That's what I was doing. I work at FSU. I can't move. By the way, I was in the Air Force. Last time I fired a gun was an M16 in basic training, and I missed the target mostly. I'm not a shot. She also described to me how she knew the details of the crime scene, which sounded very precise, like someone that knew what they were doing. It's impossible she could actually think I did this. I'm a clumsy, absent-minded professor with osteoarthritis and a bad shoulder. I mean, so I don't know if she said that to you guys. I know you can't tell me that. But she was telling people in her social circle, apparently, that there was that they shouldn't contact me, I guess, that, this was really a possibility. And that just seems deeply suspicious to me. A lot of these people aren't really close friends with me, but I found out about this crime third hand. And that just struck me as incredibly strange. And suspicious, very suspicious. I just got a couple other things and then I'll answer your questions. Yeah. I talked to Hale and I talked to you. One of the things that we might want to go over in a minute is when I talked to Officer Hale, I know you guys were under pressure. It was a crisis situation, as you were saying. But I was given a list of the men that I knew Wendi had been involved in to some degree. And a lot of times it was just suspicion of sexual involvement. I didn't know, but clearly she talked to them about a lot, so it'd be worth looking at. And Officer Hill, or Investigator Hill, was very polite and kind to me, even given the situation. Just simply wasn't interested in the long list of names. He said we're looking for a degenerate. We're not looking for these kind of guys you're saying. And I should have been more assertive, but she doesn't hang out with degenerates. This is actually a contract killing. There's going to be rich, powerful, influential men. And so there's some names that you didn't even want to write down. So that's the one thing from the previous meeting that was a thing. Just to wrap up the Wendi thing, 10 days later, she texts a friend of mine and says, does Jeff ever even want to talk to me ever again? And
Who was that?
To a Fran Gamori, who's a mutual friend. He's pretty certain she was involved in this too at this point. She'd been down to the house, visited the family a couple of times since the crime, describes it as it's just a bizarre environment when you walk in the room, so secretive and weird. But I mean, that was just strange because she didn't do anything wrong. I didn't do anything wrong, and she by not contacting me, why would she say that if you guys told her not to? I don't want to get my own relationship stuff tied up with the crime stuff, but it's just strange. Called Officer Hale and said, hey, just so you know, Wendi has a key to that house on Trescott. So I know there was some mystery and discussion and speculation how the guy get in, or I don't know the crime scene details, but Wendi's constantly losing keys. So, and rediscovering them, all the time.
Right.
So she had keys. He didn't call me back on that, and I don't know if it was helpful or not. And then here's just a list of strange things that she said after the crime. I talked to her 3 or 4 times. She said, I love Tallahassee. I wanted to remain in Tallahassee for the rest of my life.
These are phone conversations?
These are phone conversations. Danny has so many enemies, it will be impossible to figure out who did this. He's a pretty beloved man, and he was an abrasive guy, but that's a strange thing to say. I've never heard any sympathy from her one time about Danny. She still seems enraged, obsessed, and defiant about Danny. I told Officer Hale that her and Charlie went to dinner maybe 3 weeks after the crime. Charlie called it a celebration dinner via text. She puked on the table during the dinner after Charlie said something. She wouldn't tell me what he said. She said Charlie made a remark and I just puked everywhere.
Celebration dinner?
That's what Charlie called it. You can look up, if you have access to text, you can find out. Yeah, that's what she called it. When she was just in town, she was cracking jokes about Danny getting his head blown off. She said the kids are having problems, but not because of Danny's murder. So the kids are peeing the bed and having natural kid stuff, not because of Danny's murder. That's a really weird thing to say. Most people would say they're upset because their father just got killed. It seems to be important to her that it not be because of that. She was very upset that I attended Danny's memorial service. When the Tallahassee Democrat ran the story, they put must have been her worst nightmare. Front and center picture of Jeff Lacasse in the second row, sitting next to Stephen Tripodi and Frank Amori. She was telling people, like, why would he do that? He hates Danny. The man died. It doesn't matter what I thought of him. He died. He's my colleague. And then lots of strange and erratic behavior. She mailed me back every gift certificate I ever gave her. Just came in the mail with no return address. Started dating a woman that Wendi knew tangentially. And once Wendi found out about that, she called her and made sure, I don't know what she told her, but that blew up on me. So there's this aggressive component that people don't often see. And then when she was just in town last time, she asked Fran Gamori, she's still painting me as a stalker. She said, do you think there's any chance I'll be giving my talk and Jeff Lacasse would come and maybe just attend the talk? Or Fran said, she's actually irritated with her. She said, why would he do that? I actually left town while she was here because I didn't know, small town, I didn't want to run into her. I actually fear her. So that's my list of things. And when I go through all that in my head, I come to the conclusion, as you said a minute ago, that she was at least aware this was going to happen, and I think probably involved in it. And I got a list of men here. I don't know if you want to see that or not.
I'll take your list if I can read it.
Yeah.
Also, I'll write it over
Can
again.
I just tell you? I mean, that would be easiest. It's not that long. There's 7 entries.
These are
men that she was that she spoke about a lot, and I don't believe she would be honest with you guys about this sort of thing.
she spoke to you about.
Yeah, and or I knew she was at conferences with, and or I suspected she had sex with. I still suspect her and Charlie did this, but I know you guys have to look at everything.
Go ahead.
Yeah, well, there's Daniel Sack, there's Mihul Patel.
Hold on a second.
Yeah.
Sack?
Yeah.
S-A-C-K, right?
Yeah, just like it sounds.
Mehul?
Mihul Patel. Patel. There's Miguel Edmondson.
Edmondson?
Yeah, it's like Edmondson. There's 2 guys named Trey. They're different guys. One's in Destin as a real estate lawyer. One's in Orlando as another kind of lawyer.
T-R-E-Y?
There's T-R-E.
Trey?
There's 2 Treys.
Okay, Trey, that's all you got, just first name?
First name. They're both Facebook friends with her.
Okay, one's
a real estate lawyer in Destin. And one's in, actually the other one I couldn't swear is a lawyer.
and another Trey, T-R-E.
Yeah.
And who's a what now?
I think he's in Orlando. I don't know his profession. I think he's probably a lawyer. Most of them are.
Okay.
There's a person I only know as a gastroenterologist, a GI doc in Miami that I believe she was seen in early July. He was at her house an awful lot right after the crime.
Here?
No, I mean in Miami.
Okay. In Miami, gastrointestinal physician in Miami?
In Miami. And I never heard of him until July. All of a sudden, it made me a little suspicious. All of a sudden, he's around in July. This happens, and he's around after the crime, too.
Okay.
So I wondered.
Okay.
Then there's these conferences she attends, and I don't want to be too graphic, but she comes back from, if you're interested in people that were obsessed or sexually involved, she comes back from conferences with slap marks on her ass. It was very obvious what happened to her at conferences. So she went to the British American Project conference in London in the fall of 2014.
After the death.
2013. Sorry, that's before the
Okay.
death. And there's a lot of rich, influential guys there. And she goes to the Coca-Cola conference in Atlanta. There's this very wealthy advertising executive and an assistant coach for the Cleveland Browns that she was hanging out with there. I know this sounds crazy. How could they be involved? But those are men that.
And she told you about the Coca-Cola guy?
Yeah.
She got a name?
Just no rich guy, advertising agency, Coca-Cola. But he's at this conference in, when was that conference? April of 2014. She attended that conference. There wasn't that many attendees. And pretty sure she had sex with him. I don't know if that means he killed anybody. And it's the strengths coach for the Browns. I think he's Google Browns coach, Coca-Cola scholar. He's on there.
The guy that's the Coca-Cola executive is also the strength coach?
No, it's called Coca-Cola Scholars. It's a program, a conference. So there's 2 guys there. And Wendi had talked to me about having sex with multiple guys on multiple days. So I don't think you can say, well, she was at the conference, she was with Mehul, so she didn't have sex with this guy, So she was bragging about that.
Okay, so I got Daniel, Mehul Patel, Miguel Edmondson, 2 Treys, a GI doc in Miami, and at a Coca-Cola conference, there was an executive and a strength coach for the Cleveland Browns.
Yeah, an advertising executive. It's actually from the biggest advertising agency in California or something like that. He's a really heavy hitter. He's a really wealthy man. The reason I mention that is you couldn't talk to Wendi for 10 minutes and not ever talk about her situation with Danny Markel. So I know one of the theories might be that someone took it upon themselves to do this, and that I'm crazy and none of this is true. I don't believe that's true. I just want to give you every bit of
I'm with you. No, I'm with you.
I believe very strongly that she had something to do with it. There's too many coincidences here, and this is just the stuff where I felt like 100% confident I can tell you this is true. I had a lot of impressions, and there's a lot of other stuff I could babble about all day long.
So I'm clear, when she went to this Coca-Cola conference in Atlanta, she met not just one, but two guys. Is that what you're saying?
She talked a lot about, Mihul was at that conference.
Okay.
Mihul used to send flowers to the house. I'm sure they had an arrangement of some sort. And she spent Christmas with him in 2013 as well.
What does he do?
He's a rich guy in New York.
Just a rich guy.
He's a banker, I think.
And this Sack, he was a professor, right?
He's a professor.
Which law?
No, he's English and humanities. I mean, I know none of these people pop out like, well, they're a killer, but I'd be shocked if Daniel Sack was involved. Daniel Sack never wanted to meet her kids, wanted nothing to do with their divorce or family stuff. I can't imagine.
What about Miguel?
Miguel hated, I told him this guy, I know this. Miguel hated Danny. She showed me texts about how much Miguel hated Danny. Miguel and her dated right before me, his relationship preceding us. They only broke up because he moved to DC for his job and could not be here. And she often talked about the fact that she could be with Miguel if she lived in Miami.
What does Miguel do?
Works for ExxonMobil. He's a CPA.
CPA?
He's a heavy hitter in Exxon.
So Miguel Edmondson is a CPA for ExxonMobil.
Mm-hmm.
Relocated to DC.
Mm-hmm.
Man, my handwriting is getting atrocious. Well, you do this all day long, and then you pick up one of these, and it doesn't work good.
Yeah, it's all school.
Okay. Went to DC and hated Danny.
Hated Danny.
What did the text say?
I can't remember what it said, but I remember Wendi going, look how much, because I did not know that she was still seeing Miguel. I believe that she was. She had one weekend, she went away, and she only stayed at her house, which was foolish given the game she was running. Because like flowers and cards would come from other guys when I was at that house.
Well, you're there and she's gone?
Yeah. So a box of chocolates got them from Miguel, and I looked at the envelope and you could sort of see something about last weekend, and you know what I mean? So I'm like, oh, geez. So I think her relationship with Miguel was ongoing. I don't know to what degree, but she saw him in October 2013. She went to DC and saw him. That's after we were dating, and I believe she met up with him a few other times. But she told me both Miguel and Mihul she was interested in being in a relationship with, but they could not live in Tallahassee. So that was one of the other motivations for wanting to get out of here.
But Miguel had been in Tallahassee?
Even in New Orleans, even close enough they could kind of see each other on weekends.
How'd they meet?
They met at the 2000. If you Google his name, the first thing that comes up, if you Google their names together, they both traveled Europe together in 2009.
Wendi
and Miguel. Yeah, he hated Danny though.
But give me a specific, Jeff.
Yeah, Miguel went to Europe with Wendi as a group of like 10 professors. And he came to stay with Wendi when he came through Tallahassee, I guess. And he left early because he couldn't stand the way Danny talked to Wendi.
This is while they were married?
Yeah, this is 2010.
Okay.
I've always assumed the best of Wendi, that she was faithful to Danny, but Danny is described by her as very controlling and overbearing. It sounds like my experience is just trying to rein in his wife, who's not exactly the most moral person. That's my suspicion. But Miguel, per Wendi, Miguel he came to stay for a week and left after day 2. He says, I can't handle this guy. The text, one time she said, look, Miguel just texted me, and it was because Danny did rile some stuff up, and he was trying to, that thing where Jewish women have to get it's called a get.
Yeah.
Danny asked for one like in July, and it was about that she should say, look at this, what Miguel said. It was something like, fuck Danny, or just something like that. I hate that guy, something like that.
Okay. Back to, I'm curious about this episode where she vomits.
Me too.
Okay. She texted you that directly?
No, she called me.
She called you?
She called me and described it.
When was this episode? Do you remember?
I can find out for you, but I don't remember. It was not too long after the crime. It was the celebration dinner.
And what was the celebration for?
That Danny was gone. That's how Charlie talks about Danny.
But I mean, you don't hear that firsthand. She tells
me that. She says we went out for what Charlie called a celebration dinner.
Because Danny's gone.
Hip, hip, hooray.
Did he say, look what, I'm assuming he didn't say, you're welcome, sis?
Nothing like that,
no. No, but they had a celebration dinner, and what caused her?
It sounds like something out of a movie, right? Someone does something they wish they hadn't, someone makes a remark, they vomit.
Okay.
That's what it sounded like. But she puked on the table at a 5-star restaurant.
Okay.
Or at least a 4-star restaurant.
And she texted that.
She called me and told me about
she
it.
Called you.
Yeah, she did. And we were still talking at that point.
Okay.
When I started dating that girl, that was it for us. Didn't talk after that. She was very hurt.
When you started dating that girl?
It was a long story, but long story, very, very short. She said, she knew this woman, and she said, I should introduce you guys, because we decided, probably not going to be able to continue this, but it was in this limbo because of the crime. And I said, hey, you should introduce us sometime. And she sent her an email to introduce us, but we'd already been dating. I didn't want to bother Wendi with that when she's dealing with a murder.
Right.
And she texted me scathing texts, like, I never want to talk to you again, and that was it. So it was super,
Are you still with this woman?
No. And then Wendi calls her the next week and makes sure, I don't know if Wendi called her or what she did, but they have some mutual friends. This woman says, shortly thereafter that conversation, this woman said, I'm not interested in seeing you any longer.
Okay.
So, which I thought was pretty aggressive. When I texted Wendi, I said, hey, put me through a lot of shit. Give me a break here. Just stay out of this, please. And she didn't. Very aggressive.
Let me go check on something. You good on water?
I'm good, thank you.
Still trying to get that photograph. I don't know if it's still gonna be on his Facebook page or not. I just want to see it. I just want to confirm this is the individual.
I think I'd recognize it if I saw it, at least it was the same photograph I saw.
Yeah.
Photograph I recall was 4 guys like this.
Okay. Okay. All right, I got the men that you're talking about. She made, well, first of all, does she still have the same phone number?
She switched her phone 3 or 4 days after the shooting because she thought you guys had bugged it.
Okay. All right, do you have the new number?
I don't. I think she has the same number. She has a different phone. She just
Oh,
wanted
different handset?
Which is silly because you don't need to put a bug on a phone physically.
Right.
I mean, it's funny.
Why would she be concerned about people bugging her phone, or the police bugging her phone, I guess is what she's specifically concerned about?
She's real concerned about that. She told me that.
Did you ask why?
No, I knew I immediately thought she did this. And so she told me 50 times, Jeff, I had nothing to do with this. And I always just let it be silent. Sorry. I just let it be silent because I didn't want to go there. I didn't want to point my hand. I've never said anything to her. I just wanted to listen. I was hoping she might give me something interesting and I would come tell you guys. Because she's erratic enough, I thought she might say something stupid. She must have said 50 times, I had nothing to do with this. And you saw her statement in the press. She's worried for the safety of her and her children. No one's suggesting a serial killer looking for Jewish warriors, you know? I mean, this was pretty targeted, so.
Yeah, you think, she's concerned for her children's safety.
Wendi plays the victim so well. To me, it looked like classic Wendi. Everybody else felt bad for her. I thought, holy crap, she did this. She plays the victim instantly. She's great at it.
You said something a minute ago, and I didn't want to interrupt you, but I know it was about something about Charlie getting shot.
Charlie getting shot?
Yeah, I thought she said something about, I thought you were telling me that Wendi was up here or had said something about Charlie getting shot or Charlie getting killed or something like that. She referred to that.
Danny or Charlie?
I'm sorry, Danny. I'm sorry. I'm totally confusing you.
Yeah, that's okay. That's okay. Danny getting shot. Oh, when she was up here, how's this for awkward? My best friend sat next to her at a bat mitzvah. He refers to her, just so you know what it's like in the community, he calls her the murderer, common conversation. He is convinced. I don't know how, I mean, a lot of people, and that's not from my take on it, that's his take on it. Right. He knows I could be crazed. He had to sit next to her at a bat mitzvah for 4 hours. She's cracking jokes about Danny getting his head blown off.
Head blown off?
Yes, cracking. And I can't remember the exact joke, but that was how he put it, at least. And he said he looked at her and said, Wendi, that's totally inappropriate.
Where was this at?
So it was the Andrew Epstein's daughter's bar mitzvah.
Okay.
which was 3 weekends ago. She was here for 4 days. And in the morning when she was here, it was a church ceremony in the morning, the party at night. In the morning one, she sobbed through the whole thing. Whenever anybody asked her, like, what's going on? She didn't say I'm sad. She said, I'm nervous, I'm anxious. I've seen a lot of grief. I'm a social worker. It's really an atypical reaction. It's real strange. And then the evening, she was pretty much herself, but she was cracking jokes. She told some of my friends that she's changing their names to Adelson. She still hates Danny more than you would ever think. And no one has ever heard her say one sympathetic thing about Danny Markel to this day. And it's just weird. Why would you be hanging on to anger? I mean, it's so, I can only think of one reason: to make the world make sense to you. But yeah, she was cracking jokes, which sometimes people deal with pain in that way. I get that. But I mean,
how did she say it? How did he tell you? She said it.
He might have sent me here's what she said. There was one just general joke, but I have the other text. He said, my favorite quote from tonight, I overheard Wendi saying, at least it didn't happen to Jeff or the kids or somebody I actually cared about.
Okay.
So that was the vibe. Those two, they split this town into 2 piles, I mean, it was a nasty thing. But people that aren't me, because I'm careful, I haven't told anybody the story like I've told it to you. I've told people I'm suspicious. That's about all I've said. They find her behavior erratic, bizarre, scary, and people who are very close friends to her are coming to the point where they're like, Jeff, I'm having people stopping in my office saying, Jeff, is there any chance? It's just not the Adelsons in Miami. Is there any chance they had something to do with this? That's the weirdest family, the vibe. You walk in the room and something's strange. I know it's all subjective, but it helps me to hear that because I feel like I'm a crazy person for the last 6 months. I've been waiting for you guys to arrest some vagary, I mean, and those names I give you, I mean, that's so you have all the data I have. Wendi with Charlie. I don't know who pulls the trigger, but there's a very strange relationship between those two. I acknowledge this might all sound real crazy to you, Mr. Gary.
I'm not, no. So I'm very interested in this.
Yeah.
I want to make sure that I understand it completely and thoroughly.
Yeah.
And I can see that it's been weighing on you heavily.
Well, it has, because it sounds crazy to people, honestly. Although I told a couple of people the whole story like I told it to you start to finish, and no one else has said I'm crazy. My therapist said, one thing I forgot to tell you, I had to go get a damn therapist. It was so crazy. So I tried to manage her. I tried to get some advice on relationships. And in April of 2014, he tells me, look, he's real blunt. I'm going to be honest with you. 2 possibilities. One is she's just getting over a divorce, is drinking too much, and she'll settle down over time, maybe live happily ever after. Second option, she sounds an awful lot like a sociopath to me. That's an objective person.
Right.
And I said, sociopath? I said, yeah, high functioning, but she doesn't seem to have a conscience. And I said, oh, Jesus, what I got myself into? Because I was in love with her and I wasn't going to leave at that point. But that's the kind of feedback I've gotten when I tell people what she's actually like.
Okay.
I prefer that you guys catch somebody else, obviously.
Right. When's the last time you talked to her or had any conversation?
I could find it for you. It would have been in around August 20th.
Oh, that long ago.
Yeah. She cut off all contact because I didn't tell her I was dating. It was just bizarre. That was the time, it was about the time of commencement, summer semester commencement. That was another thing as far as narcissism and a crazy person. You know what Wendi was mostly upset about? And she told me this. The fact that she had to cancel her commencement speech because Danny was shot. Her attorney said it's a bad idea to get yourself in front of the media like that. Inside edition will show up. You can't do it. She was devastated. It's bizarre.
I went back and looked. Apparently you all have somebody, McPherson.
Jay McPherson.
Yeah. What's the relationship? Is she has something to do with Wendi?
They claim that she was in the room with Wendi in the 9 hours you guys interviewed Wendi.
Oh, she came up here. She was not in the room with her.
Wendi told me she was in the room.
Well, okay, let me correct that.
That sounded weird to me.
She came in the room, I think it was over the children. The children had to be picked up.
Gotcha.
And there was two ladies that were up here, and I can't remember if that was McPherson or
No,
not.
Jane was with her that day. And coincidentally, Jane's one of my doctoral students in our program. So she's getting her PhD in social work. I teach in social work, so I know her professionally.
Right.
Jane is the one I talked to for about 3 hours, maybe 2 weeks after the crime. They told me that Wendi and her circle of friends thought I did this.
Jane told you that?
Jane told me that. She said you had to be there if you were, and she basically made it sound like if you, and she's a confidant of Wendi. See, Wendi has told many people that I stalked her, that I falsely accused her of cheating on me, that I'm this very mean person, all this kind of stuff. And she has friends that are professors in other departments. She's slandered me pretty bad. So I just haven't responded to any of that. But I go to conferences and get weird looks from people. Anyway, Jane is the one that I was so puzzled because I'm a pretty gentle guy. I was always a really good father to those kids, essentially. I didn't understand how anybody could think that. And I don't believe that Wendi could have possibly believed, like, why in the world would I go shoot Danny? Did I want to choke the shit out of her? Yes, but I would never touch a woman. And I've been in a fist
So
fight.
you said, you just got through saying what I want to choke the shit out of her.
Yeah, her, not Danny.
Right.
There was a few times where I took a time out. I teach anger management classes. You know? I might raise my voice to her that one time. You couldn't. She would collapse.
Okay.
But Jane knows Wendi as well as anybody. Jane doesn't think any of this. But Wendy's pretty good at fooling people. Although some of this information is publicly available, I should add. Like, she's a Truman scholar. If you go on the web and look at her statement, she says, "I hate Tallahassee. You're a bunch of country bumpkins." That's basically what she says. You know.
Although I think she told a lot of the locals
What they
that
wanted
she
to-
was satisfied, she wanted to make the best of things, and that she actually.
No, that is what she said. And not when the door closed and it was just me and her in the house. Then it was, I mean, I got tired of listening to it. I think it's a great place. I deliberately moved back here. I couldn't went anywhere. I mean, so.
But it wasn't for her. And she made that clear to you, is what you're saying.
On a daily basis. You couldn't pull up to the movie theater without hearing about how the movie theater in Miami is better.
Okay.
She was obsessed with it. You know, her and Danny thought they'd be here a semester. Got stuck here. So.
And then and all she'd been wanting to do is get back to South Florida. And she made that quite clear to you.
Like, I mean, it was kind of cold, actually. She basically told me, if it's between you and South Florida, I'm going to South Florida.
Okay.
I'm trying to think if there's anything else. I heard that the FBI had maybe talked to her brothers. Oh, that's the other thing. Her brother Rob in North New York. He's, I don't think anything to do with this, but something very weird about this family. There's some emails between us where when he visits the house, he doesn't even talk to the parents. There's just some sick dynamics where Wendi at one point told me that dad was extremely violent. And I thought, well, this makes sense why you're so gun shy and, you know, hair trigger. And then later I said, well, with your history of family violence, he said, I never said that. So there was a lot of inconsistencies in the line, but I don't think Charlie's been up here. If you were, your experience and instincts, you were to talk to Charlie, I assure you, there's something off about that guy.
What about this FBI thing?
I heard through the grapevine that the FBI talked to Rob up in New York.
That's what Wendi told you?
No, I think that's what Jane McPherson told me.
Okay.
So, and I try not to believe everything I hear because misinformation is everywhere. You know?
Well, if Jane McPherson heard it, she most likely got it from Wendi.
Yeah, well, that's true. That's true.
But he's like an outside, he's not really a part of the core family.
They don't have a relationship, basically. Okay. And the impression is he's a guy who wants nothing to do with his family. There's something that happened in that house and he wants nothing to do with it.
Okay.
And I just think there's, that's the other theory, which sounds super crazy, but the people that have visited the house in Miami said to me, has anyone considered maybe the whole family's in on this? I mean, this is I said, people don't do that. I said, well, you go in that house, it's real strange in there. It's real secretive. It's real weird.
Have you met her parents?
I have.
Is there anything that you can tell me about them?
You know what autism is?
Autism?
Yeah, yeah. The dad and the brother Rob have this reputation of being like that. They everyone in that family suffers from a severe lack of empathy for other people. She learned that somewhere. You know, pillars of the community. You get on his website. I mean, years ago I went on it. He was polite to me, but dad's polite, mom's kind of rude, actually. I know that father has been speculated about. They hate Danny in a way. I have a wife. I've been through a divorce. I get life. I've never seen this kind of obsession. Like their hobby is hating Danny. It was like really strange. I mean, and I fell into this because Wendi could convince you of it, and maybe she convinced the parents. But they were going to put you said you looked at some emails, but not others. At one point, Wendi was going to get a restraining order against Danny, which in retrospect is bizarre because he was a good dad. But she had Gary, you know, Gary is a lawyer that he's the one that offered Wendi the job so she could relocate in the summer of 2013. He runs a tort firm suing drug companies. He offered her $1 million job, and I wondered about him too. It's not sexual; it's more of a father-daughter thing, but they're close.
Gary.
I don't know his last name.
Where does he work?
He's a lawyer. He works in Miami.
Okay.
He owns a tort firm, and their emails. I mean, she sent this document. It was like she had compiled every email, like between Danny and Wendi, for like a year and a half. And the idea was to make this legal case that Danny is harassing her and stalking her. She always goes to this. She told me Danny was a stalker because he looked out the window one time and saw her walking down the street without the kids, and he goes, "Where are my kids?" I have right of first refusal. If you don't have the kids, I should have the kids. Wendi claimed that was stalking because he said that, you know. So anyway, all these emails, and the idea was we're going to persuade some judge that Danny needs to be reined in. I read this document. At this point, I'm a little skeptical because she's screwing everybody else. I said, this is an indictment of Wendi Adelson's character. You read this thing, you get the impression this woman is a total loon. You know, it was interesting because she thought, like, from her point of view, it showed what an asshole Danny was. If you were to read this, it's like this person is crazy. So that was when I started to figure that out. But there's that different perception. At first, she seems really together, and then just loses her mind. So my worry is that she had something to do with this, and has no conscience. And it's hard for me to believe she could. I know you can't give a polygraph. I can't believe she'd pass a polygraph. I can't believe she would stand up to repeated questioning if you guys had any leverage. I understand that this was done in a smart way. I don't have any leverage. But my experience with her was over time, she just collapses. You know.
Okay. Well, I get I understand that, you know, that you never heard Charlie say anything derogatory about Danny.
Oh, are you kidding me? Yes. Yes.
Did you hear him say anything in a threatening manner?
No. Well, I myself said I like to kill Danny Markel. I told you guys that because Wendi told me he was sated. I don't want to make it up. In that hot tub, this is what this family talks about. In that hot tub, I don't remember. He definitely in that hot tub, half the conversation was about what an asshole Danny Markel is. He was very heated up about it. He's a very intense guy. It was a little different than what I would say it, you know, Bandito's great. I was like, someone should kill that guy. I was so sick of his shit. Really, it was Wendi shit. I was manipulated. The brother, I mean, they were married 9 years. They have 10 years worth of the bullshit to be upset about. And the rant and rave about how he handled the wedding.
How he handled the wedding?
You know, kosher versus not. You remember when he did that at the wedding? What? Sure. I mean, it's like their hobby. It's bizarre.
And I didn't have that written down. When was the hot tub conversation? That was right after the March 12th?
Yeah, it would have been like March 17th or 18th. Would have been the Sunday at the end of spring break last year. But if the question is, did he threaten Danny? No. If the question is, was he pathologically upset with Danny in a way I found disturbing and that put me off and it was different than, say, even Wendi or her mom? Yes. Incredibly intense about it. Incredibly intense. Charlie's so difficult to get along with, he doesn't have one dental office. He works at 5 dental offices and they can only handle him 1 day a week in each office.
Really?
Yeah. And he seems to know this and strategize it. He's figuring out how to make it work for him, but he was a special ed kid, I believe. He was very difficult to get along with. And he is fiercely protective of Wendi. He had suggested seriously that they convert to Islam.
The whole family?
Just Wendi and the kids.
Islam?
Islam or Christianity, one or the other. Just to screw with Danny.
So they're not very devout in their
No,
Jewish
they're atheistic Jews.
Pardon?
They're atheistic Jews, Jews that don't really believe in God. They do it culturally, they eat the food. These people don't have ethics or morals. I mean, they don't.
Immediately after the homicide, you came back, and I'm with that, and then you reached out to Wendi, or she contacted you?
10 days later, she texted a mutual friend acting as if I would be upset with her.
Right.
And I said, tell her to call me. She did. At 3 in the morning. She wasn't sleeping well. And we had a very awkward conversation. Mostly I think literally she talked for an hour and a half, and I said probably 30 words. I just listened mostly. It was real. She wasn't sleeping. It was real crazy. But that's where she told me a lot of things that weren't true. I mean, and that could just be a relationship thing. I mean, I couldn't contact you until Ginny Judkins talked to you,
right.
I believe. And I don't know. I thought it was really strange not to. All my friends were texting with her, and she wasn't writing a lot back, but everyone else she acknowledged. One of my concerns, tell me if I'm paranoid, is Wendy's no dummy. She knows I know all this stuff. Now, she may not remember everything she ever said, but if there's one person, what she told me at one point was, no one knows me better than you. I said, who have you been intimate with in your life? What people have gotten to know you? Because she's a very superficial person. She said, 2 people have ever got to know the real me, you and Danny Markel. So it's been kind of anxiety provoking to get what happened to him. But in that conversation, there was a lot of lying.
Okay.
And I thought that it wasn't like my feelings were hurt, but she said someone get killed. If she was literally a victim, I would just say, take as much time as you need. I don't care. But there was something weird.
Okay. Let me see if this picture's available or not.
Okay.
It may be off. obviously, if there's something else, we can meet again.
I got one other quick thing for you, actually.
Absolutely.
Wendy was advancing her withdrawal schedule from the antidepressants much more rapidly than is safe. And she stopped, she told me this after the fact. She dropped off the med completely on July 14th.
Well, we determined that's the date that the conversation happened about Charlie and the 15,000. But she doesn't tell you till later on.
I just said, hey, how are the meds? And she goes, oh, I stopped those. I think the first day I was back, which was Monday, July 14th. That was my first day off. So she's off them completely on that day.
Okay, so.
Which, by the way, people have impulse control problems at that point, so that might be why she said that. I mean, it's.
But she's telling you this when?
In August sometime.
Okay. She just stopped cold turkey?
I don't know. I just know that supposed to go down 10% a week. She wasn't doing that.
Okay. Okay.
If I think of anything, I'll get back in. I actually had two quick questions for you, if you don't mind.
Yep.
This is completely selfish, but I'm concerned about me in this situation. I'm wondering how long it is, in your opinion, before the media, before journalists are poking around looking at this case. And I'm worried about my potential exposure as a professor and as a person.
This is an open case. They can ask all they want to. They're not getting anything.
Okay. And that's what we're seeing.
I mean, I may call you. I mean, at some day you may be called as some type of witness.
I would do it in a second. Yeah.
Okay, I want to make sure that we're upfront about this. I mean, let's say it goes from here to an arrest to a prosecution.
I'm there.
And for some reason, your testimony is needed.
I would say anything I said today under oath. I would.
Okay.
So that's easy.
All right. But as far as anything prior to, anything that you're telling me, if for some reason that was, leaked to the press or anything like that, then I got an arrest to make of somebody else, no matter who it is.
I got you.
Okay.
I got you.
Does that set your mind at ease?
Well, mostly. The other question is, I was foolish enough to trade emails with Investigator Hale. Now, those, if the case ever does become closed, those are public information, are they not?
They would be considered public information, but someone would have to request them. And, for that, it would be something specific they would have to request.
I just saw the ones that leaked from Jameis Winston and went, oh crap, is this going to happen to me? Am I going to be, you know what I mean? Because Hollis and I talk about her allegations of stalking in his emails. I'm like, oh, great. So.
I would not worry about it.
Okay.
I mean, I don't see a concern there. I don't know exactly what you and Hale.
I just sent that email that you showed me, and my header to it was, does this sound like someone who's being stalked? This says I'm trying to work this out with you, maybe, or maybe not, but there's no mention of that. So.
I look at that as you're showing a defense for why you would not be.
And then one other email I sent him, I pretty much accused her.
Okay. But I mean, obviously it's more than that. I mean, yeah, you more than just suspect her at this point. That's what you've been telling me this afternoon, right?
No, that's true. That's
what I've basically gotten from you is this woman is directly involved.
She is.
Now, I don't think you're saying necessarily that she killed her ex-husband,
No.
but she either had something to do with orchestrating it or had knowledge that it was going to happen. That's the whole point about I have to be back on the 18th, right?
No, give you a thumbs up, and then and know what's going to happen. There's something weird about that date. So I don't think she doesn't have the skill to orchestrate it, but Charlie does. So that's correct. And
But you left on Thursday, and your last conversation with her was on Wednesday.
My last conversation with her was on Tuesday. Right. An hour before that email where she says, look, I need a week.
No, on the email, she says she needs a week.
Yeah.
An hour before she sends the email, she says, are you still in town on Friday?
That's exactly right.
And you said, I don't know, it's still up in the air, but she did not ask you to stay in town.
No, she did. But like the next day I see Jane McPherson at work, and maybe, there's all kinds of possibilities how she would have found out I was leaving. Do you have any suggestions if I know they're doing a dateline on the Frosch guy that killed his wife out in Thomasville and they already came to town. Any just advice from being an experienced investigator, what I should do if I'm approached by the media, because it's not unimaginable.
Go talk to Investigator Eisen.
Okay.
How simple is that?
That's easy.
And come in, Paul voice. We're gonna make those dreams come true. Do it our way. Da 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 da. Da 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 da. Dun, 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 dun. Hello, everybody. Oh, how Jeffy Poo, Jeffy Poo, Jeffy Poo. Ginger Snap is snapping off up in here now. How's everybody doing? Everybody act normal. Paul's back. That was perfect timing, I guess. Well, it's been a busy lunch, y'all. I made cringy thumbnails, so be on the lookout. They're coming to a sofa near you. Took the dogs walking. Hey, Audra. Took the dogs walking. Ate lunch. Talked to Derek. Annoyed Matt. You know, the usual. So, y'all, what we're doing is we are waiting. I mean, it should be coming back on any minute. And then we're going to be waiting for the afternoon session. And the afternoon session, there's no telling where that will go. So, stop the bra talk. I'm drinking an iced whipping tea. Ooh, that sounds amazing. Oh, my goodness. I'm tired. I got up early. Went to the gym. Here we go. Mr. Everett's like.
All right, 2 matters to briefly address.
There we go.
Bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Mr. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf. Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do.
What is that scope?
The information that we discuss after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily.
Tell him, Judge Everett, he's not putting up with it. Talking about we don't have time. Makes me sick to my stomach. Hey, Northwest. Hey, Sandy. Hey, Amber Emergency. Hey, Christina. Hey, Mandy. Iowa. And Heather. Bandit. Melissa. Jojo. Ginger. Emily. Yay, Emily's all safe and sound. Miss Chris. Art House. Y'all, so yeah, literally y'all. This is crazy. I think that they just want to say, they're just stalling. I think it's 2 things. Now, I'd like to hear from a real lawyer. I think it's 2 things. They're stalling for whatever reason, I don't know, and I could be wrong. Or they're like wanting to 100% see how everything goes. Or she hasn't decided. I don't know. I personally would not testify, but this is the Adelsons we're talking about. They think that they can, talk their way out of it. And I guess this would be my question. So let's say they're stalling. Why? What for? right? Are they waiting for a witness to show up? Like what? I don't understand. Trying to establish appeal issues. That's a good one, yeah. Oh, I hate that feeling. Bandit says she fell asleep for 20 minutes and woke up disoriented. Yes, I know exactly what you're talking about. It's like the day is just done. Emily was on a plane. Ooh, she didn't complain. Ooh. Avoid a Friday afternoon deliberation. Yeah, that sounds legit. Yep. Because they already know. You could be Monday, 8 o'clock in the morning, okay? I can already tell you about what's going to be happening. It's just a matter of how long. Scared me to death, Luke. It's just a matter of how long it takes. Come here. What you doing, buddy? Hey. Hey, what's going on? Oh, here we go.
That has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we're not going to do this for very long.
The way that the judge talks, like his approach, we're not going to do this for very long. Like he's a very measured man. You know what I'm saying? Like a very measured. That's the only way I know how to say it. He's a very measured man. She's going to be up there talking about, here's my issue. Now, hear me out. Now, you listen. This is very important. You listen. She's going to talk to him like she did the hitman. If I get up here and I start going on and on and on, okay? You see Harvey? He's in the second row, okay? His heart can't take this, okay? What if he drops dead in the courtroom? What if he drops dead? Yeah, it's like I thought I'm waiting for them to say on the what do you call it, on the internet, the peanut gallery of the internet. Yeah, they're definitely saying things. Hey Izzy, what's up? Hey Izzy, what's up? Hey Izzy, what's up? So y'all, for everybody just joining, we are basically in a standoff between the defense and the court. And the court is like, okay, well, is she going to testify? Meaning Donna. And Donna, something's going on. And so now they've asked to go to a sidebar to make up the decision. Oh, thank you for being a member for 12 months, Avery. And thank you for your compliment. I appreciate you and you being here. So we're waiting to see. Donna clearly has some kind of issues going on, right? That she's like, over. Good boys. What good little boys. Donna says, listen. I don't want to get up here and get caught in a lie. And I'm not saying I'm going to lie. I'm just saying I might get confused. Oh, thank you, Izzy, for the super sticker. I appreciate that. Izzy's on a plane. Ooh, she didn't complain. Ooh, I have that song in my head today, y'all. I'm sorry. It's Emily's fault for being on a plane. That's what triggered me. And somehow we made the connection from Emily flying in the plane to Nirvana on a plane. So that's just kind of where we're at today. If she gets up there, it will literally be pure rage bait. I know she wears those headphones everywhere. She keeps them on now. She might have a shank on her. She's been filing that thing away. She's just waiting for this moment to get up there near the judge. She's like, I know a sure way out of here, Sammy. And I ain't talking about the dude who set me up on the street. Yeah, I wouldn't want to go up against Georgia either, right? For own personal entertainment reasons, I too would love for her to take the stand. I mean, let's be honest, right? Yeah, courtroom Jackie is like, she's like, now, Judge, I'm waiting for these words coming out of her. The way I used to run my courtroom, honey, he'd clean the floor up with her in a very measured way. I can't complain. I'm on a plane. Jules, that's funny. I think if Donna takes the stand, oh, thank you, Jessa, for the $2 thing sticker super chat. We'll just throw all the words out there. She's afraid of combusting if she swears in the Bible, literally, right? Her name. Okay, so hey, Tori, Paul. Her name is Jacket Jackie. Okay, yeah. So courtroom Jackie is Jacket Jackie. Oh yeah, she'll have her medical condition on the stand. That's a given. Hold on, we're gonna find this. Y'all have got to see this. Hold on, I'll do it at a break, but I mean, came right up. Hold on, let me see if it's what I'm thinking of. This is it. Yeah, we're on our way. So I found the clip of the dude who pretended to fake the heart attack in court. We'll watch it on the one of the other breaks. They're not going to tell us? We deserve to know this information. can't believe they didn't tell us.
Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you. At this point in time, the defense will call Marisol Descalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated. You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Grashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call ethics counsel and call the Florida bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time. We had previously discussed that I represented Mrs. Adelson. So I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't. No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not, I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband, as something that would help her with her mental state.
Okay. So that's something they suggested, but not you.
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going,
Okay.
and it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, the prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Incoming Paul. Incoming Paul. Incoming Paul.
Let's recall Sarah Newhouse.
Sean's in the midst of a heat wave in Southern California. Legit? What is that out there, Sean? Sean's gonna be like, high 80s, low 90s breeze. We're dying out here. Harvey, get me a cardigan. SoCal. We need a cardigan in SoCal for Sean. I legit think I will end up living, when I say, he's somewhere on the West Coast eventually. California, Washington, Oregon, somewhere in that. The weather just seems so amazing. That might be hot for y'all out there, though, Sean. I don't know. I'm just picking.
Please come up to the witness stand.
She seems timid.
Raise your right hand down. Do you swear or affirm?
83 in Colorado. That's amazing. Oh, Ghost is in San Francisco.
Speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendi Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendi Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendi Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay. And is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother?
It is.
Okay. When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I move into evidence Defense 71.
An objection.
I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that objection.
A lot of qualifications.
Well, they're just.
Members of the jury, we're going to take a brief break. The bailiff will take a deep jury round.
Y'all, we are just creeping by today. Creeping. Hey, Lauren. What's up, girl? Hey, Lauren. What's up, girl? Lauren. What's up, girl? So, y'all, so what's going on is the here we go. Please hold.
If anyone needs to stretch their legs or use the restroom, please do it now.
So, Georgia. I know. Sean says, I said badly want to see Georgia versus Donna Showdown. Same. So we don't know. There's a bunch of back and forth for those who are just joining. If Donna's going to, testify. We don't know yet. They did a sidebar. The judge was very upset. The defense wanted more time to figure it out. Judge was like, no. So I don't know if Donna's like, well, let me see what they say on the stand. Let me consult with Harvey. Let me talk to Harvey. Yeah, I think you're right. I think that she's trying to make it so the judge has to say tomorrow she's gonna take the stand or not. She knows what she's doing, okay? She knows what she's doing. Harvey's asleep. Harvey said, "Oh, good Lord Almighty! I thought so. Where am I? Where am I? And where's my pants? Where's my lovely wife? I was just having a nightmare. My beautiful, darling Donna. She was incarcerated wrongly, might I add, wrongly." You're right. There's the peanut. There's the peanut gallery.
Includes Wendi Adelson saying this is the worst day of my life before the call connects. And then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now. So subject to those objections, no objections to the exhibit once those things are removed.
And as I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing comment before and comment after before it's published with the jury.
That defense 71 will be admitted, the proper redactions will be made, and bring back to the jurors.
She's like, "Listen, your zipper's down. It's been down the whole day." I know it is. Donna said, "Really? The zipper's down? I didn't notice. There's so much fabric." This poor girl, she's just like, "I'm just trying to get back home."
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know.
Correct.
Do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the file.
Please sit down. As to the hearsay, sustain.
No further questions.
Redirect.
Your Honor, move to strike the question from Ms. Kaplan.
Members of the jury, you are to disregard the last question of the prosecutor is to be struck from the record.
Hey, Mad.
Will the witness be recalled?
No, Your Honor.
Georgia rang the bell, though. She rang that bell.
Do you wish to publish or distribute?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. They will take you to the jury room once again.
Just leave him in the jury room. Just leave him back there.
Everyone can be seated. Please make all necessary
Right,
redactions
Peachy.
and changes at this time.
I mean, make your little edits, defense. So, if for people who are just joining, this is kind of how the whole day has gone, right? Just kind of this little back and forth, ping pong, tennis, the jury and the. Donna's like, oh, so it's muted. I don't know why. Oh, they're not supposed to be. Okay.
If there are no other witnesses for the defense, it is time for the decision to be made.
So no char.
Tell the court that the co-counsel and my client are deep in conversation. Starting this.
I am capable of seeing that, Mr. Zellman. No narration is needed.
I can narrate it. Come here. I see you get on the stand and you have a heart attack. But I've already done 3. I used 1 when I was in holding to get an extra peanut butter sandwich. They gave me 2, as a matter of fact. I could just urinate on myself. I think you're going to have to urinate on yourself, Donna. Okay, I'll urinate. I'll get up there and I'll urinate. And then I'll have the heart attack.
Once the defense rests, is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise.
Okay, that's it. I'm peeing on myself, y'all. I'm doing it. It's going down my leg.
Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the 2 rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, as I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity.
Yeah, this is bigger than any soap opera right here. This is bigger than any soap opera. I can't. And she had the gall to say, I don't know, Judge. We've been talking over here. I barely had enough time to get the 2 peanut butter sandwiches. I just urinated. Nobody's doing anything. I want me to just sit like this? And this, y'all. This is crazy. This is 100% theatrics. I mean, I do think that Donna is this type person. Like, she's just like this, you know what I mean? But she is manipulating. This is theatrics. This is going to go into, I want a new trial. Like, this is, to me, it's just courtroom theatrics. Yeah, I do agree. She's probably like, put me up there. I have nothing to hide. They've got nothing on me. Harvey's over there. He knows they don't have any evidence. I think that, again, I'll say it 100 times from the rooftops. If you watch Arrested Development, you will know how this family works. They live in absolute distortion. They live in absolute non-reality. They live in the portal. Okay. And she probably still thinks that she's innocent and that everybody else would see this. I'm on a train. Her name is Donna. Something else. Something else. Her name is Donna. Yeah, distortion. Yeah, they are absolutely in distortion. Emily rode a train. Ooh. It was really a plane. Ooh. I want to see her testify so bad, y'all. It's killing me. This is killing me. And you hear after this, if she doesn't testify, if she doesn't testify, that's it. That pole's just zooming. Yeah, Charlie Palmer. So, I mean, oh, wait, hold on. What's this? So, I guess Charlie is there for a holding pattern for anybody. So, maybe the state would bring, I mean, I don't know why he's there. Does anybody know why he's there? She's like, I can't face Georgia. Sweet Georgia. I'm headed on the midnight train to Georgia. Woo woo. There we go. Hold on.
Mrs. Elman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided.
The room saying no. The room saying no.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Everybody's conferring today. Yeah, I gotta confer with Bo and Luke over here, y'all. We need an extra 5 minutes. Okay, this is what I think she wanted to, and her defense team told her no. What do y'all think? Because she said they're like, at this time, I don't want to. Yeah, this would have honestly made y'all. Can you imagine? This would have made everything. The way she said it, this time I'm going to say no, and she acted like mad, makes me feel like she wanted to, but the defense is just like the one brilliant thing they did. I mean, let's take oh, Shayna, you've been a member for 12 months. Thank you. If they don't have a plan. Okay, a good point, Shayna. Pardon me. They probably weren't. So Shayna brings up a good point. If she was going to take the stand, they might not have even prepared for her to do that because she obviously has been wishy-washy. And if they,
I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors. Or we can decide the language now. If you find that more acceptable, it's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. I will give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, the counsel have a moment to confer concerning whether or not we are going to rest at this point.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness to find.
Now they're going to decide if it's Charlie. That's my thought. They're going to decide if it's Charlie. What a disappointment. We might get Charlie up there. That'd be equally as good. Probably even better, right? I mean, let's not lie. It would be good to have Donna up there. But yeah, they probably didn't have a plan like Shane was saying. So it's almost like, okay, what do we do? And I think Donna's also like, put me on the stand. Y'all don't understand. You heard what I did on the phone call with the hitman. Okay, I can make things happen, you know. And they were just like, girl, don't, right? They're like, I know that, you know, we literally got our licenses out of a Cracker Jack box. And, you know, a little, you know, Larry, Curly, and Mo over here lost hers or something. That's why she's here. But the one thing we can all agree on is you don't need to be getting on that stand. Okay, period. Because you would think also there's some level, even though they're completely like this, you know, by the seat of their oversized pants kind of defense team, that they only have Miss Chris says ChatGPT. ChatGPT said no, girl. I'm screaming. You know that's exactly what it was. When they said that we emailed the things, I was like, I know that they're going to say they didn't read it. I was waiting for them to be talking about we lost our password to the email. We can't get in. We can't get in. We got to do a password reset before we can check our email. We got to do a password reset up in here. and the internet's not good in this room. We got to go downstairs for this. Oh my gosh. They're like, okay, well, what is the password? We're going to do it on the screen. The defense of they're talking about, it's she's fried. 01 exclamation point. Capital S, lowercase HE, FRIED 01 exclamation point. Oh, I'm dying. I'm giving myself a hot flash up in here now. Oh, here we go.
Are going to be tendering 2 exhibits to the court to introduce. I believe that both qualified or hearsay exceptions. State's indicated that they're objecting. If I could just have a moment.
Yeah, I thought he had the Bible. I was like, we're getting biblical. we are at the last straw. We've gotten biblical. He's talking about tab 32, solemns, this, that, and the other. May God save your soul, this, that, and the other. Okay. I guess that was their lawyer, Law for Dummies 101. You know those books they used to do? Right, Bandit. Yeah, Lori definitely was breaking out that Bible. Yeah, Donna looked, but see, this is what she wanted. This is what she wanted. Yeah, please, Amy says, that's all we need next. She'll be calling Chad Daybell, talk about the veil. I mean, yeah, just that's what I thought was even weirder. I was like, why does he got the Bible? Like, what's he going to do? Oh, she's feeling a certain way. Yeah, so for those just joining, Donna has said no to testifying. She will not be testifying. I don't know. I feel like she wanted to, but I feel like also that she would have, it doesn't matter what the answer is going to be. She's going to always act like whatever it was is not what she wanted. She's working on, she's not completely stupid, right? Probably not good at crime, but not completely stupid. She's been manipulating for a very long time. She knows what to do. Okay. It doesn't matter what the answer is. She's going to be unhappy with it. And I mean, honestly, it's in her best interest too. Okay. I would be unhappy with it. I'd be like, shh. But y'all did me wrong.
Gentlemen, concerning the items, we do need to move on so a ruling can be made.
Sofa Jackie is on her way up.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is, I believe it's states 51. No.
Kettleman, concerning these items, what is the state's argument?
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023, where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who is going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized
I
by.
believe as the inculpatory matters, yes, as to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted, not that she was.
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. So these are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research. But again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just one.
Yeah, they're exhausting.
The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband. And the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry on the 14 planner that was admitted, that has been admitted so far in this trial, is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. 23 planner was identified as a file witness as it being seized from the residence.
I'll reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for the record, what I've done is I've marked the 2013 excerpts as defense, 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please begin the jurors.
And Judge, the state has made the, I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct.
Yep. Jurors are fine to come in.
All right, you're entering the courtroom.
Everyone can be seated. Defense may call its next witness.
All right, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow, you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45, and we will get started at 9 o'clock, or at least attempt to. Have a good evening. Everyone can be seated. Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought? 3.2, statement of the charge. Any requests or changes?
Nothing to say.
Your Honor, the only request that I would make is that the name of my client and the names of the charges not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note. Moving on to 7.1, introduction to homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all category 1 lesser includeds?
Just confirming my recommendation being approved by my client, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well? It's category 1.
With the although it's a category 1 lesser, still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a category 1 lesser?
Yes, sir. Yes, sir. We'd be requesting all lessers.
Well, all category 1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform the indictment, we would request his full name, Your Honor.
Acceptable.
If you find Daniel Markel was killed by Donna Adelson, You will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requested.
Just a moment, Your Honor. I would agree with the court's conclusion, Your Honor.
Mr. Evans, Ms. Koppelman.
No objection, removed.
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
No, sir.
Your Honor.
All right, 7.4, second degree murder. Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
The second definition, an act is eminently dangerous to another and demonstrating a depraved mind, that must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7 manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on? Well, A and B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel. Right. Concerning the state versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And defendant agree with that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions? Go ahead.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
She said yes.
Please discuss it with the bench.
Thank you.
I mean, they are going to sit there and drag this out. I mean, yeah, I personally think Donna looks sick to her stomach, but I mean, again, anybody would, right? It's like we're at the finish line here almost. We got close-ins, and here we are. So it's, again, here we are. Yeah, today has been the theme of we didn't have enough time to discuss. The judge has been like very lenient with him and giving them an extra 5 minutes extra this, but yay, Ultra's in Colorado. She's headed at CrimeCon. Enjoy your walk, Emily. Hey, hairball, how's it going? I know. Yeah, this has been like, oh my gosh, here we go.
Ms. Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that.
You are giving your consent to this. Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard? In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No. There you go.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested. I believe as to the first paragraph where it says attempted homicide cases. Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for.
Correct. I believe that instruction must be given for first-degree premeditated murder. And all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markel occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, It is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Owens.
Yeah, you have to intend the act, but you have to intend to kill.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor. Not sure that manslaughter is included in that, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
It's fine.
And so you can contact me on that, Judge, and I'll let you know at the later this evening.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as a second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those? For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. Excuse me, I've moved down, the principal's already connected with that. So I ask yes or no. There's no evidence that the defendant in this case actually possessed a firearm, so no, we're not requesting.
It will be removed. (3.5) sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proves beyond a reasonable doubt. Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion that says crime or attempt, the crime that the state is requesting, is that first degree murder?
Yes, sir, but I don't believe that, I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I think this crime is the appropriate one given the standard judge.
I'm going to look at the standard briefly, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, Your Honor.
I would ask that the individuals, Secretary Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and/or other persons.
For count one, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction,
3.5 sub B, element 3.
yes, sir, but I'm saying for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, but we'll read the crime was committed by the other person as to the persons who committed the crime, and the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
Am I reading, this is the new instruction?
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current
Yes,
instruction.
we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All four.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanois, and or other persons to cause the first-degree murder to be committed, either by them or one of them, or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanois and or other persons. So I think it could be.
You're just requesting an and or between the names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding and or are, it can include, basically, if you put something or, I mean, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanois or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine Magbanois or other persons. It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. And lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
We agree, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine Magbanois, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine Magbanois or other persons to commit first-degree murder during the solicitation, which are being requested by the state. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine Magbanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area.
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they were previously defined. Or do we need to?
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter, whether it can be argued that someone is a principal and solicitor.
Thank you.
For now, I will just move the two instructions to the end of the counts.
In the counts, it just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately, no instruction can be argued as to the offense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
I'll just add at the bottom the principal theory. Or actually, this instruction does not apply to count two. I'm going to do that for both principal instructions. All right, moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
Basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
It's probably number 10, so I don't know we're not, but it's 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain to the next set of give as applicables. Law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
Have it typed out for you, just like.
Yes.
Copy to the defense. Sorry about the typo in the title. And the certificate of service. All on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Just a moment. I have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it's just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence. opposed to, because it,
You're asking for this then to be inserted into the tip, or what
Yeah.
would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. And it sort of leaves it hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. All right. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested.
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
So, stop here. So we're, for the record, as I understand it, of the bracketed languages under accomplices and informants,
Who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
all right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That is be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness that will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
There you go.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
No, Your Honor.
Cautionary instruction, does either party wish to be heard?
No, sir.
No, Your Honor.
Single defendant, multiple counts, does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count one, we the jury finds as follows as to count one of the indictment, first degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first degree murder. Option B, defendant is guilty of the lesser included offense of second degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count one. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is the raise?
The only thing I would suggest we leave them involved that makes it clear for the jury to differentiate between each of the counts, but I don't have any real strong feelings, but I see why they would be involved.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer for the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count two, we the jury finds as follows as the count two of the indictment, conspiracy to commit murder. Check only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count one?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
The same reason why I'm asking for the names of the charges to be in regular caps, not all caps throughout the instructions. It's the same principle.
State that you have a position.
Your Honor, I think it's, to me, when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it the most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count one, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C. So it's not up under the check box. But other than that, I think throughout the verdict form, we're going to be asking the same thing. Leave it as is because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, I will grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. Two options, guilty and not guilty for count two. Same two options for count three, guilty and not guilty.
Yes, Your Honor, for count three, that you move it off page 16 to the top page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages. All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't tell me too much.
Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, all the exhibits.
A demonstrative is not admitted, so yes, I would agree. It is not go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before you're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
Believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter. It is not necessary for the state to prove the defendant intended the death of Daniel Markel. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically asked to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right, once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
Incoming Paul voice. Incoming Paul voice. Incoming Paul voice. That is right. That's what I said. Jakey poo poo. So, y'all, tomorrow. What time? 8:30 tomorrow recess. I guess they start at 8:30. Is that what you said? Is that what that means? I'm one moment away. Da-da-da-da, da-da-da-da, da-da-da-da. Okay, so yeah, major. State is rested. Things have been outlined. All the stuff is there. Tomorrow we have closing arguments. This should be very interesting. Our lovely Georgia has said about 2 hours for the state. I mean, you know the defense is going to get up there, and I mean, who knows what they're going to do, right? Let's, whatever. So here's what we're going to do. Like I said earlier, and first of all, thank you, mods, for hanging out, for keeping everything going. We've had mods in planes, trains. They've been on a plane, ooh, and in a car, ooh. They both went real far. So defense has one last issue. They're not letting us hear it. So thank y'all. Thank you, Jackie Hearn. Let me do this because she might not be hearing it. Thank you for your on the ground reporting. Thank you, Emily, Audra, Tux, everybody, Lauren. I hope I'm not missing somebody. Audra, Tori. My brain's kind of fried. So now you already know, if you followed me for years, you already know what the T is. What happens on major days and times. Paul has something planned. Now, what does this mean, though? This is not that serious. So I have a telehealth appointment at 11 a.m. Probably when they're going to, and I'm going to tell them. I'm like, look, let's make this real quick. Wait, do what puppies are... Wait, what are you talking about, just Joe? I don't know puppies or ringworm. I pick puppies. I'm gonna pick puppies. But I see what you're saying. So no, the telehealth thing is for me. So it'll be real quick, and I'm gonna keep this going. I'm gonna do it on my phone because I'm like, no, we ain't missing it. So we'll be streaming in the morning, hanging out, doing our thing, and then we're just gonna be waiting, right? So yeah, there you go. We thought Donna was going to testify. No such luck. So there's that. So I am going to go to the office and record. I might hop on the Patreon live when I get there, like we did yesterday. I just got to see if I get everything set up and timing and everything. And it'll just be a surprise, whatever, if I do. So there's a new feature on Patreon where you can go live directly from it, and we tried it out yesterday. It was fun. But again, I'll see, and it'll be obvious if I do. That's kind of it. So I hope everybody gets a good night's sleep, nice and rested. And I'm glad that Emily was on a plane. Ooh, she didn't complain. I had to find a reason to say that one more time. Sorry. But thank you, Sofa Squad. This is so much fun watching these trials with y'all. So allegedly, Sarah Hartfield goes to trial. Jury selection is the 29th of this month. That will be the next one that we watch for this month, and then we'll roll into Brian Walsh. If it's televised, I'm not sure yet, and you've seen how things have gone. Oh wait, hold on. Please hold. Emily was on a plane. Ooh, she didn't complain. Ooh. Oh, do y'all see the dogs? This is what. This is what's going on over here. Bo's right over here, but he's eating his little bone. He was very upset. No, we don't bite. He was very upset. No bite. know. You just be lovely. Say hey to everybody. Say hey. Oh, he wants to play. Come on. There you go. So oh yeah, it's playtime. So I'm gonna go do that. The dog's gonna play, and that's just how things are. So I'll set up the live chat for here to tomorrow. And there you go. I think we could have a verdict depending tomorrow, certainly in the morning or by Friday. What's today? Wednesday, Thursday. By Friday morning, if not tomorrow. So there you go. Anyways, thank you, mods. Thank you, squads. I love y'all. I will talk to y'all here a little bit. We'll close out with Slow Morrison's Ode to the Sofa. Arr, arr, arr. It's all day long. Okay. I love y'all. I'll see you.
The pillows are fluff thanks to Miss Emily. The couch is wide enough. Join the family. It's all love while we laugh at first criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Oh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.